Good morning, good morning, good morning, Leonard. It is Wednesday, it's August 6th. Yes, I always have to check what day it is because most of the time I forget. Replay crew, everything will be timestamped down below because we're going to court today and we have some documents to cover today. We really need to just cover what's going on in Kouri Richins, and it's probably going to be the last time, honestly, that we cover Kouri Richins for a little bit. So let me know what you're coming in, what you're drinking. I've got a cappuccino, and Leonard's, be so for real. Tell me if you bought Crust White Strips because of this case. For those of you new to this case, don't you worry. I'm going to do a road so far. We're going to look at, the audacity of one of the subpoenas that's gone out in this case. And then we're going to go to court. This hearing was Monday. We're going to peek in. It's a Zoom hearing, but the camera does face the judge better. So, the camera does face the judge better. So we've got that going for us. So we will pop to take a look at what happened in that Monday hearing. There are going to be a lot of hearings as we get into the new year in this case, as it runs up to trial in February. And there will be a lot of filings between then. My hope with the filings in the Kouri Richins case is to grab all of the filings together. So to do the motion, the opposition, and the reply and kind of do them all at one time, not as they're dripping in, because I know there's going to be a bunch of them. They're going to talk about that in this hearing, I'm sure, because scheduling is a big part of what they're there for. And I haven't watched this hearing, so I'm pretty sure they'll talk about it because they talked about it at the last hearing, so I'm assuming. And then we really won't see a ton about this case because the lawyers are going to be doing a lot of work on their motion work, their motions in limine, and everything that needs to run up to trial. And then they're going to deal with trials. So we have lots to talk about, but it's going to be a minute. Does that make sense? Like, cases have their slow points while everybody's working on stuff. And so that's what we're going to be doing. So let's roll the intro. We're going to go to Utah today. We're going to just be in Utah today. And we're going to go to court. We're going to see Attorney Bloodworth. If you are new to this case, will you just pop a 1 in the chat? I'm going to roll the intro. We're going to do a road so far. We're going to cover a document. We're going to cover a motion to quash. Oh boy. And then we're going to go to court. Sound good? All right, Law Nerds. We it's time.
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
It's true. It's true. Let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Okay, so if you are new to the Kouri Richins case, this is a case out of Utah. It is now 2 separate prosecutions. The trial that is coming up is a homicide trial. Kouri Richins is accused of murdering her husband by poison due to financial stress. If you start going, it's giving Murdaugh. Yes, but she's not a lawyer. She is a boss babe who is trying to flip houses, who does not seem to be doing that very successfully. And we went through the entire new indictment with all of the allegations of mortgage fraud and general scamming. Emily, that's not what it is. No, it's mortgage fraud. It's money laundering. It's literally getting your bestie evicted while stealing allegedly like $50,000 from bestie. There's also an affair, hers, that it comes up because there are text messages back and forth to the paramour, which is how her side piece is referred to in the filings, indicating things like, don't worry, he'll be gone soon and I'll be free by Friday. And then her husband is found dead. She has been trying to pass it off as an accidental overdose, but alas, when there are accidental overdoses, there are often indicia of that around. Like you will see the narcotics or whatever it is, pills, whatever, you will generally see them around the area. That was not the case here. She has tried to say that they were weed gummies laced with fentanyl. However, her Facebook Messenger messages and text messages and things belie that allegation because she is asking someone to purchase these things for her. And then there is an alleged attempted homicide where her husband becomes very ill after eating a breakfast sandwich on Valentine's Day. The prosecution is going to bring in an expert to indicate that the things Eric Richins, the victim in this case, was saying he was feeling to friends in the moment. These are present sense impressions, so they're going to come in without hearsay. The things he was saying in the moment were consistent with fentanyl poisoning. He survived that and then was killed by fentanyl, later had 5 times a lethal dose in his system. I have cat glitter. So the messages from her are like, I need stronger shit. And then there's the Google searches of like luxury prisons for rich people and can law enforcement find deleted messages, and why would the FBI be involved in a case? And if someone dies by poison, what would it say on a death certificate and things like that? And then there were life insurance policies he didn't know were taken out against him, etc., etc. So Kouri Richins is an interesting one. We've covered her walk the dog letter, which was recovered from her jail cell. The prosecution is going to likely use this in trial, though we are waiting for motions in limine. Kouri said it was part of a book, and then her lawyers said it was attorney-client communication, and then she said it was all fiction. And what it says is, this is what her brother needs to go tell the lawyer, because this is how we need to connect these things together to make this accidental OD, laced weed gummies story plausible. And she continues to get into it with Eric Richins' family, the in-laws, because they are still battling over his estate in other litigation. Now, if she is convicted of murder, it's going to change the way that she goes after Eric Richins' estate. But yes, she's been going after Eric Richins' estate. Their 2 kids are with Eric Richins' sister. Eric Richins' sister is the executor of the state and the executor of the trust. Kouri didn't know that. Kouri also didn't seem to consider that Eric might have made some legal moves to try to keep her from getting his things should he die. So there's a lot going on. And the legal fight with the sister-in-law, there was also a physical fight with the sister-in-law. When I covered, and we will link the Kouri Richins playlist to this video, but when I covered the bail hearing, because she has been in custody, no bail, when I covered the bail hearing, the sister-in-law testified and they got into a physical fight. Well, Kouri throat punched her sister-in-law. It wasn't that they got into a fight. It's that Kouri swung on her sister-in-law after finding out that the sister-in-law owned the house and the safe and the money and the property and the rest of it. And there was a continued fight over the estate of Eric Richins. A lot of that is going to just wait until after the criminal case because it'll clear some things up. There's a lot of evidence in this case, from text messages and digital evidence to a witness who Kouri asked to purchase fentanyl from, who said, no. So it's going to be an interesting trial. We know a lot about it just from the preliminary hearing and the bond hearing. And it's also one of our favorite judges. The thing about this case is, though, the parties are quite interesting. I find sometimes the defense attorney and the way they argue, both of them, to be amusing. The prosecutor is also amusing. That's who's on the soundboard saying every law nerd on the internet knows it's Docket 214. Attorney prosecutor Bloodworth is delightful and kind of snarky. And then the judge is just so even-tempered and has a delicious voice. And so everything about this case has proceeded really professionally and really easy to follow because everyone just works together. Even when the parties are advocating or they are making positions in court, they are also agreeing on getting things turned over. They're agreeing on what needs to go forward. It is a much more normal process for a case, which is really nice to see after some of the wildness we've seen in other cases. So while I don't always agree with the defense attorney's arguments, they are just doing the best they can with the facts that they have, which are not great for their client. It is not a case that you look at and go, I wonder what happened there. It's a case that's a little bit more obvious. So of course they're going to fight all the things you fight ahead of trial. Change of venue, which was denied, motions in limine, which haven't started yet, and the rest of it. So this is going to proceed in a more normal way. The things that are interesting is the digital trail that Kouri was leaving and the surprise, your husband isn't just leaving you all of his money. That's real interesting. And then seeing how these things are going to play out in trial, if she's going to testify, those are the sorts of things. We're looking at how Docket 214 is going to come in, all of it. So it's just, sometimes it's nice to cover a case that despite the facts being difficult and sad, the process of the case is proceeding normally and professionally. And that's really nice to see. So Kouri Richins is going to be going to trial in February 2026. We are going to take a look at this first docketed item. We're at docket 1001. Yup. That's how many docketed items there are in the Richins case. This is a motion to quash a subpoena. When we talk about motion to quash, think of just motion to squash, like to just squish, go away. So motion to quash a subpoena. We're going to see who the subpoena's to. Y'all aren't going to be surprised. The financial case is going to go to trial after. That hasn't even been set yet. The financial crimes case was recently filed. So that's going to take a minute. I feel like we should fly to Utah since we're still parked at Logan. And all of you are like, how did we get from 214 to 1001? I know. All right, let's go. Hopefully you brought snacks. I brought snacks. This is a scheduling hearing when we get to it. So it's going to be interesting, but it's not going to be like earth-shattering court. It's going to be normal. This case has been pretty normal. It's nice to see everybody being normal. You'll notice immediately that the lawyer has indicated that they are the spokesperson for the Eric Richins family. And you're like, Emily, the victim's family lawyer is filing an objection to and a motion to quash a subpoena and for sanctions and a request for a hearing. Yup. I wonder why. Who could be subpoenaed? Comes now, Gregory Skordas, spokesperson for the Eric Richins family, files this motion to quash subpoena under Utah Rule of Civil Procedure 45E and Criminal Procedure 14. They are asking the court to quash in part the subpoena issued by the defense counsel, Kathy Nestor, attorney for Kouri Richins, dated June 23rd, 2025. Impose sanctions and attorney's fees. Like right out of the gate. Sanctions. It's just coming in hot. Like my coffee. Like my coffee. Referred defense counsel issuing the subpoena to the Utah Office of Professional Conduct for ethical violations. They are so mad. Just so mad. Immediately mad. Just 0 to 60. Normally with a motion to quash, it's just like quash the subpoena. This motion to quash is like motion to quash, fuck you, and a little bit more of fuck you with a side of, but how dare you? I want the subpoena quashed. I want them sanctioned. I want them reported to the, Professional Conduct Board for ethical violations. I want somebody's butts. I want them now. Shame on you. Shame on your cow. Like all of it. So pissed. Kristen, fuck you. You're cool. Fuck you. Exactly. Katie said, sounds like this person might be a civil attorney. Yes, Katie. These are civil attorney games. Criminal attorneys tend to ramp up this. Oh, I did mean dishonor. I meant dishonor on your cow. Yes, shame on your cow. Don't shame the cows. All the things. Kathy, this is a great question. I'm going to hold on to this till Q&A because we talked about it a little bit when we covered the civil cases. Any other relief that the court deems just and proper? By the court, we're talking about the judge. This judge is just so rational, so easy to deal with, and so tempered. He's just going to take a minute. He's not going to just immediately go to sanctions. The attorney first responds to each of the numbered requests in the subpoena as follows. This is what the subpoena is for. All right. Objects to disclosing all emails, letters, text messages, personal or professional correspondence between any employee of the Summit County Attorney's Office, which is request 1A of the subpoena. This is also written like a civil attorney. The basis for the objections to this request are more fully set below. What they are saying is that the defense attorneys for Kouri Richins have subpoenaed the family's civil spokesperson, like more of a victim's right attorney, and wants the victim rights attorney's communication with the DA's office. And I imagine if there are any of those communications, they would be, hey, we have a hearing on this day. Hey, the family is welcome to attend this hearing. Hey, it looks like the case is going to get continued because they're making these motions. Hey, this is the process of the case. It would be those kinds of motions. However, Kouri Richins was recently charged with all the additional fraud charges. And some of those are information that the prosecutor's office, I think, likely got from part of the estate settlement stuff and vice versa. But if in trying to deal with probate and settle the estate and the trust, the family came across things that indicate that there might have been fraud, the family can go to law enforcement and be like, here, we think there is additional fraud. We have learned additional things. There's nothing to stop them from doing that. And there's nothing improper about them doing that. But you don't get the communications. Also, what's the basis for that in the criminal trial of Kouri Richins? Like nothing. He goes on to say, the attorney, that he never communicated with Detective Jamie Woody and does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1B of the subpoena. Attorney has never communicated with Detective Jeff O'Driscoll, does not have any communications as requested in 1C of the subpoena. Attorney has never communicated with Eric Root. Put an asterisk. I have questions. And does not have any emails, letters, text messages, or personal or professional correspondence as requested in 1D of the subpoena. 1D. Skordas, the attorney, has never communicated with any employee of Summit County Sheriff's Office and does not have any communications. And they list it, emails, letters, text, personal, blah, 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 as requested in 1C of the subpoena. Hey, I don't have any of this shit. Also, how dare you? Also, he's allowed to talk to who he wants to talk to. He's the family's representative. SCOTUS does not have a retainer agreement or engagement letter with any of Eric Richins' family or the Eric Richins Living Trust as provided to provide as requested in 2 of the subpoena. Hey, did they hire you? He could be a family friend. He could say, hey, if I'm the family, because he signed this as the family representative, spokesperson for the Eric Richins family. It might be, hey, give people my info so they're not trying to track you down to ask you about this case. All requests will just run through me. I'll talk to the DA's office and keep you guys in the loop. I got you. It might just be that they know each other. Who knows? That's also allowed. Continuing on. The attorney objects to disclosing emails, letters, text messages, personal or professional correspondence with any member of Eric Richins' family as requested in 1F of the subpoena. Yeah, why do you get that? The basis for these objections are more fully set below. His communications with Eric Richins' family, what are the grounds for that? Because I don't see any. And we don't have the underlying subpoena, or at least I haven't found it. It goes on to say SCOTUS does not have a retainer agreement or engagement letters with any of the Eric Richins family or living trust to provide as requested in 2 of the subpoena. SCOTUS does not have any checks made payable by the Eric Richins family or the Eric Richins Living Trust as requested in 3 of the subpoena. Mr. SCOTUS works for the Richins family pro bono. And yes, they have the same last name because Kouri Richins, that's her married name. I'm sure her sister-in-laws are like, Joe Shamrock, we're going to cover the status hearing that was from Monday in just a few minutes. But also, we got a lot of new members because the law nerds are doing all of the things. B2 gifted 50 memberships. Thank you. If you've ever been like, I wish Emily would talk more about DCI, go find the tech test video. It's in your member spaces, new members. Welcome. Thank you, B2. That's incredibly generous. Thank you, Tina KS Loner. Thank you so much for the gift of memberships. You don't have to do that. Thank you. Lauren ET, thank you for the 5 gifted memberships. Sassy J in the UK, thank you for the gifted memberships. Matt Bond reminded me that I forgot to talk about the children's books. Kouri Richins was promoting the children's book that she wrote about grief when she was arrested for the murder of her husband, whom she wrote the book about. And it's playing out in the civil arena because part of those civil cases is the misappropriation of Eric Richins' likeness in the book that she sold about helping her children through grief before the world knew she was accused of killing their father. Just wait. The law nerds on the internet will never, but everyone else is going to call her something stupid like the children's book killer. We're just going to call her Utah versus Richins or Walk the Dog or a combination of the two. Continuing on. I saw a few of you going, can they make Kouri Richins change her name back? No, they cannot force her to change her name. Wouldn't it be funny if they could? I vote for luxury prison lady. Yeah. Or just wannabe. We're going to wait till after trial, Emily. Put it back in your brain. Put it back in your brain. I have snark for this case. We know a lot that's gone on in this case. There are some cases where I come in and I'm like, I'm really interested to see how they prove this case. This case, I come in and I'm like, really interested to see if you testify or not. Because I don't have warm feelings for this defendant, and everyone in court is innocent till proven guilty. But the evidence that's stacked up against her proves that she is not as smart as she thinks she is. And I'm going to have to start borrowing words from older sister Gonzalez, because I think we need to just, I think basic might be the biggest insult in this case. Emily, you do not allow us to insult. I know. I'm going to have to rein it in. I know. I know. I know. I know. I'm going to have to rein it in, but Olivia can, thank you. Olivia can just pull everybody's card, because I wonder if Eric Richins, I don't assume that they watched what was going on in other cases. It's probably hard, but I wonder if the Richins family will ever watch what Olivia had to say and feel like, yeah, I feel her, because they're in this very strange place where not a lot of people have lived through what you've lived through. And it's different when it is somebody's spouse. This is for the victim's family. This, again, it's familial. This is a domestic case. This is a spouse accused of killing a spouse. It is different than someone walking in off the street. It is a different level of breach of trust. But also, they are now raising their deceased brother's kids. And so I'm sure there are times that the kids look like Kouri, talk like Kouri, and the family is raising them. At least they have a piece of their brother, but they also have a piece of Kouri. That was their sister-in-law. And I just wonder if Olivia's words maybe resonated with them in a different way, or if one day they will be able to tap into that. So, Rachel, it is Eric's family raising them. So, but I'm very clear when I am, when I have feeling some kind of way about a case, and I didn't. And then there was the bail hearing, and then there was the preliminary hearing. And you know what really did it in this case for me with a lot of it? The forensic accountant. Paper doesn't lie. Bank accounts don't lie. Like, you know, sometimes bitches be lying. And that is a pejorative to all genders. Pick one. Or any. Or all. But paper does not. Bank accounts do not. Bank accounts just do what they do. And once you bring in that financial component and look at the where the money is going and the pattern of time, you're like, well, that's what the money's doing. All right. Back to this ridiculous subpoena. I'm not saying the motion's ridiculous. Like, who is subpoenaing the attorney for the victim's family? What are you thinking? What are you thinking? Also, if you're having an affair, just, I get, like, it's easy for me to stand here and be like, just get divorced. If she got divorced, the prenup says she doesn't get the money. Right? This case and the Adelson case have these things in common, where it's not just, it's everyone in the family that's destroyed because of the horrific and untenable choices somebody made. And I know that I would love the world to be better. There's times maybe I'm too optimistic about that, but I'm often an optimist at heart because I worked as a DA for too long. And if I'm not an optimist, then I just stop going outside. But I am often an optimist at heart. But I also know that kids can be dicks. I'm not telling you anything shocking. And I feel for the Richins kids as they grow up. I really do. Just like I feel for the Adelson kids. Because everyone knows your business. And there's no getting away from everyone knowing your business. Everyone's going to know their business. And I fucking hate that for them. And if Kouri and Eric had just gotten divorced and she had like filed for bankruptcy and had to be like, oh my God, not luxurious and rich, It seems like she could never. Yeah, maybe there would be some people who have judgment for that, but I'm sure there's plenty that don't. So this is worse. However, Kouri gave a from jail interview thing a while back and said, nobody understands. And I'm like, sure, Sarah. I mean, Kouri, it wasn't intentional. Sure. Sure. Nobody understands. Sure. We understand your Google searches. Let's continue on, because Google searches alone aren't the thing. So Mr. Skordas is working for the Richins family pro bono. Motion to quash and for sanctions and attorney's fees. T. This is the T. I mean, and I do mean sure, Jan, but but also the throwback to Sarah Boone, because it's the same thing. Kouri is giving, I excel at everything. Not crime. Mm-mm. 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 So this is going to be one of those cases. This motion seeks to quash a subpoena. Remember, when you think of quash a subpoena, just think of squash. Like, just get rid of it. To quash a subpoena issued by defense counsel that, one, demands production of privileged communications between victim advocate and victim. And under the law, when we talk about victim Eric Richins, the family members also fall under the law as statutory victims, so able to give victims impact statements, etc. So they are talking about the family members of Eric Richins. 2, demands production of privileged communications between attorney and the Summit County Attorney's Office, completely unrelated and irrelevant to the issuing defense attorney's case. What is happening? Like, I don't understand. Just like I've told you guys, I could not be like a journalist because I'm not knocking on people's doors and like putting a microphone in somebody's face. Like I truly enjoyed water polo, which is a very confrontational sport. I enjoyed trial attorney work, but both of those things have rules and boundaries. I am generally not a confrontational person. And so I don't understand pushing into the gray zone to try to demand communications between an attorney, victim advocate, and the victim family. Like, that thought wouldn't even cross most people's mind. What do you think these attorneys have? And also, it's privileged. And also, the victim's family don't seem to be percipient witnesses to anything based on the facts that we know. Of course, there is probably much that we don't know. But I don't see how this pertains to the murder case. Wild to me. But again, we only have one side of this. I just don't know what they're thinking. And I want this to have a hearing. Jules Olivia, yes, not all journalists are the same. It's true. It's very true. It's just, the instinct to push into, this might be uncomfortable for them. Like I just can't. Casey Cat, it does reek of desperation. Or maybe that's just their designer imposter cologne. Back to Clueless early this morning. The subpoena also demands production of privileged communications between attorney and the Summit County Attorney's Office, completely unrelated and irrelevant to the defense attorney's case, and 3, unduly burdens attorney by requiring him to parse through, identify, and produce 3 years. 3 years. 3 years and 3 months worth of communications with the DA's office dating back to March 3rd, 2022, when almost none of these communications have anything to do with or any relevance to the issuing defense attorney's case. He said almost. He said almost. Just.
Survey says.
Why? Why would anyone think that this is a good idea? The subpoena for extensive, irrelevant, and I mean, the defense attorneys probably think it's relevant. what do they think they're going to get? Extensive, irrelevant, and privileged communications was issued, 1, in direct violation of court rules and ethical obligations, 2, without any good faith legal basis. This is why asking for sanctions. 3, for an improper purpose, apparently to burden Mr. Skordas unnecessarily by asking him to produce 3 years and 3 months worth of communications with the Summit County Attorney's Office, the vast majority of which have nothing to do with the issuing attorney's representation of Kouri Richins and are also protected by the attorney-client communications privilege. 4, to harass the victim's family by requesting privileged communications between the Richins family and Mr. Skordas. I don't know where communications between the victim's family and their family attorney would ever be turned over. Like, what? I want there to be a hearing because I want the defense to explain what they're thinking because I don't get it. I would like to understand and I don't understand. The subpoena must be quashed and sanctions imposed, which the court probably won't do. And sanctions imposed under Utah Rule of Civil Procedure 45 to deter the use of defense attorney subpoenas to compel production of clearly privileged communications without any legal justification, to deter the use of subpoenas that ask for irrelevant communications, and deter the use of subpoenas that overly burden the subpoenaed party, and to protect the integrity of the process by which defense attorneys issue subpoenas. And there's more. And there's more. Factual background. I should have made tea this morning. I should have. The only tea I'm making is like the David's tea Holo Taco collab. It's so good. But I should have made tea this morning. On June 23rd, Catherine M. Nestor, defense counsel for Kouri Richins, served a subpoena on Gregory Skordas, victim advocate for the Richins family. Most of the communications requested by the subpoena are either subject to attorney-client communications privilege and or the victim advocate privilege. He said most. The subpoena requested all of the attorney's communications with the DA's office dating back to March 3rd, 2022, without any kind of limitation to requesting only communications relevant to the issuing attorney's current representation of Kouri Richins. I mean, I would imagine it would be communications about this case. If he is advocating for other families, it wouldn't be those. But if they didn't limit it, they didn't limit it. But also, the defense attorneys want what? That the DA's office said there's a hearing this day? And he's saying it's without any kind of limitation to requesting only communications relevant to the issuing attorney's representation. I want to see the court say, yeah, Miss Nestor, why? The issuing attorney knew or should have known that she was engaged in an overly broad subpoena request because Mr. Skordas, the attorney's communications with the Summit County Attorney's Office, would necessarily include dozens of communications regarding cases handled by Mr. Skordas that are completely irrelevant to the issuing attorney's current representation. He's like, well, actually, I have lots of cases. How dare you? No motion, court review, or attempt to confer occurred before this invasive subpoena was served. Oh dear. Look, as a courtesy, reach out to the attorney and be like, hey, we're going to issue a subpoena for these things. That's also common courtesy. And it seems that this attorney has more cases with the Summit County Attorney's Office, which could either be in the context of as an advocate attorney or could be in the context of a criminal defense attorney. I don't know. But also, if you're on the same side of the bench, it's like, bro, what? At least reach out to me and be like, hey, we're doing this. The subpoena imposes an undue burden, which the attorney said, seeking over 3 years of communications. The subpoena look, these attorneys, the defense attorneys in Kouri Richins' case, are clearly watching the other high-profile cases going on elsewhere in the country. They brought in the exact same expert from the Kohberger case to talk about change of venue. And the judge was like, it sounds like people know about this case everywhere, so why move it? And then the appellate court was like, yeah, we're not taking that up. We know that they're clearly watching other cases, but there's not a proctor here. The subpoena additionally seeks to expose confidential privilege relationships and communications between the attorney and the victim advocate. Or no, between the attorney as a victim advocate and the victim's family. Without any apparent basis for requesting these communications or any attempt to limit the requested communications to those relevant to the issuing attorney's current representation of Kouri Richins, there has been no attempt by Kouri's defense attorneys to explain why privilege information should be produced or to have the court make a determination on any privilege claims before simply demanding production of privileged communications that the issuing attorney should have known were privileged. You know better. The subpoena imposes an undue burden by commanding him to produce all of his communication with the attorney's office over the last 3 years, the majority of which are both subject to the attorney-client communications privilege and relate to other cases handled by the attorney in Summit County, unrelated to the Richins case. Mr. Skordas estimates that he has handled a rough approximation of over 50 cases since March 3, 2022. That's in Summit County, not total, requiring extensive communication with the Summit County Attorney's Office. It would create an undue burden of Mr. Skordas to be required to parse and sort through hundreds of communications with the Summit County Attorney's Office that are completely irrelevant to the issuing attorney's representation. Can you imagine if you email back and forth with one particular agency or place frequently? You can't just put in like at summitcounty.gov and find all those emails, because then you have to go email by email and figure out which one might even relate to this case. And even then, those communications may still be privileged. Legal standards, an argument governing the request for sanctions and attorney's fees. Utah Rule of Criminal Procedure 14 governs the issuance of subpoenas in a criminal case. A criminal subpoena may command a person to whom it's directed to appear and testify or produce to court, or to allow inspection of records, papers, or other objects. The court may quash or modify the subpoena if compliance would be unreasonable. Rule 14 adds a reasonableness determination for whether the court may quash a subpoena. 14A2 limits, the 14A2 limitation allows the court to quash or modify a subpoena if compliance would be unreasonable. And then there is case law. The subpoena in this case is unreasonable under the circumstances. The bulk of requested communications, specifically the request for the attorney's communication with the Summit County DA's office dating back to March 3rd, 2022, have nothing to do with or are completely irrelevant to the issuing attorney's case. The issuing attorney knew or should have known that the bulk of her request communications were completely irrelevant to the representation of Kouri Richins. The subpoena is unreasonable on that basis alone. They're saying it's not tailored down. I'm going to skip past attorney-client communication. There seems to be nothing to waive communication here. Further, crime victims have a right to be treated with fairness, respect, and dignity, and to be free from harassment and abuse throughout the criminal process under the Utah Constitution, Article 1, Section 28(1)(a), and cited by State v. Lopez from Utah 2020. The subpoena in this case is unreasonable. It requests extensive privileged communications between Mr. Skordas, the victim's attorney, and the victim's family. The issuing defense attorney knew or should have known. Rule 17, same thing. Rule 45, mandatory sanctions. Tell me more about mandatory sanctions. Hey, Massachusetts, you got any mandatory sanction provisions? I have a suggestion. Maybe we need to consider it. Just a thought. Just a thought. Violation of Utah Rule of Civil Procedure 45. Note, we are now in civil procedure, not criminal procedure. Let's think about that as we go through this. An attorney admitted to practice in Utah may issue and sign a subpoena as an officer of the court. The subpoena power was one of the most significant, powerful privileges granted to Utah attorneys. The extensive power to compel anyone in the state to give testimony and produce documents and communications comes with an equally extensive responsibility to not abuse that power. Emily, how do lawyers say with great power comes great responsibility? Like that? Like that? Like that? Rule 45E1 mandates quashing the subpoena that 1, require disclosure of privileged matter, 2, impose an undue burden on the subpoenaed party. The issuing defense attorney served a subpoena on Mr. Skordas that both requires the disclosure of privileged communications and imposes an undue burden on Mr. Skordas. The issuing attorney has requested from Mr. Skordas, among other things, any and all emails, letters, texts, personal or professional correspondence dated on or after March 3rd, 2022, between you and any employee of the Summit County Attorney's Office. Skordas has a large active caseload, including many cases in the last 3 years, 3 months, in which he has engaged in privileged communication with the DA's office regarding other clients represented by Skordas in Summit County. Estimates roughly 50 cases. Complying with this request would be unduly burdensome and would require him to scour all of the communications to find any that might not be privileged. It is not possible that the issuing attorney was not aware that this request would cause Skordas to comb through approximately the last 3 years and 3 months of extensive communications with the Summit County Attorney's Office and would result in production of irrelevant and privileged communications that are completely irrelevant. That's too many uses of the word irrelevant, one sentence. The issuing attorney did not even try to limit the scope of the subpoena to only relevant non-privileged communications. I would need to see the subpoena to see if I agree or disagree, but it should have been any non-privileged communications relating to the prosecution of Kouri Richins. Not all communications, period. It goes on to say that Rule 45E3 further provides that the issuing attorney has a duty to avoid burdening subpoenaed parties by not, inter alia, 1, issuing subpoenas that target communications that are privileged. He's like, the rule says don't ask for shit that you know is privileged. 2, issuing subpoenas that impose an undue hardship on the subpoenaed party. The subpoenaing attorney in this case has issued a subpoena that violates each of those provisions. Get to the mandatory part. Rule 45 provides that, quote, the party or attorney responsible for issuing a subpoena shall take reasonable steps to avoid imposing an undue burden or expense on the person subject to the subpoena. The court shall, not may, not might, shall. Shall is strong legal words. Shall is some of the strongest legal words. Like the only thing maybe stronger than shall is must. The court shall enforce this duty and impose upon the party or attorney in breach of this duty an appropriate sanction, which may include but is not limited to lost earnings and a reasonable attorney fee. If an attorney issuing fails to do so, the court, honestly, I don't see typos on my shit either. I have to read it out loud to find them. But I get it. He didn't spell withdraw wrong in the title header, so we're going to give a pass of the duplicative word. If the issuing attorney fails to do so, the court shall impose an appropriate sanction, which may include but not limited to lost earnings and reasonable attorney fees. Some of you have asked, hey, if this attorney is representing pro bono, what attorney fees would the attorney ask for? The attorney fees could ask for whatever fees would be incurred in doing all of this. Hey, Your Honor, I normally bill at this rate. I spent this many hours doing this. So they need to pay me for those hours. Because I am not, look, attorneys like other service providers, I know it seems different than other service providers, but it's honestly not. Attorneys make money in this way when they are billing hours. So if you are working on this, you can't bill hours to somebody else, but you're working on this pro bono. So it's just sunk or lost opportunity cost because you have to do the thing in front of you, but that person's not going to pay. So somebody should pay for that time because billables. So those are hours that this attorney could be working on another case it's paying or handling this case. Because when you are pro bono, you have chosen what the scope of that is. This was not this attorney's choice. This was foisted upon him. Like, why the fuck are you subpoenaing me? Pay my fees. However, the defense attorneys are appointed by the public defender's office. So ultimately, who would end up paying the fee? The people of the state of Utah. That's who would end up paying the fee. So it goes on to say the court shall enforce this duty and impose sanctions upon the party or attorney in breach. The court will likely say narrow your subpoena or quash the subpoena and not issue fees. And maybe fees for the cost of this motion, maybe not. But they go on to point out this is not discretionary. This is literally, the attorney is saying this is a fuck around or find out provision. This is full FAFO. The language in Rule 45E1 requires the court to impose sanctions. It's mandatory. The operative word is shall. Shall means, in some cases, must. This is the way. Mr. Skordas has now had to spend considerable resources in objecting to this overly burdensome subpoena and would not have had to spend time, objecting to the subpoena if the issuing attorney had limited her request to the communications relevant to her case and had not sought privileged communications without any kind of reason. Tell me why. Also, GFO. Your Honor, it says shall. They fucked around. Now they catch the find out. And the attorneys know this, right? They could have tailored their subpoena differently and didn't. John, this is great to know. John Decker said Skordas is one of the most well-known attorneys in Salt Lake City. He's run for AG and is a legal analyst for KSL. Well, fantastic. KSL's coverage of this case has been great. Local coverage has been really good on this case. But also, wouldn't the defense attorneys know that and maybe not fuck around to ensure the not finding out? And also maybe the professional courtesy, the professional courtesy of saying, hey, we are going to be tailoring this to seek these communications. If you have an issue, let us know, we can figure it out. Professional courtesy goes a long way. And there are some cases where professional courtesy is not going to work. I can't see like Brennan and Alan Jackson having a productive conversation about much at this point, but it did seem that Brennan and Alessi were able to at least work out basic things in court. Professional courtesy goes a long way in law. But if somebody burns you on that professional courtesy, the repercussions tend to be long lasting. But professional courtesy in law goes a long way. There's a lot of unspoken rules in law. I think it's why sometimes for first generation lawyers like myself, you're just like, wait, what are they all doing? Legacy lawyers tend to know these things a bit better, but you learn very quickly. Also, this will come to the surprise of no one. Have you gathered this? Lawyers can be petty as fuck. And that petty lasts. So if you fuck with someone, you have kind of fucked yourself for any future dealings with them. And the smaller the legal profession is in an area, the worse this gets. Do not mess with people. Chat, there's a story. There's a story about fuck around and find out that we don't have time to get into at the moment. Members, remind me. I know all of you are shocked. All of you are shocked. Young Black Economist said, legacy lawyer is someone whose parents are lawyers. That's what it's kind of rude to call them Nepo babies, but because they actually had to work and like go to law school and stuff, but people who have lawyers in the family. And my My aunt and uncle are attorneys. They lived all the way across the country. So we didn't really talk about their work ever. But my parents were an attorney. I did not grow up in a house where it's like your parents a lawyer and your grandparents are lawyers and their grandparents are lawyers and everybody's lawyers. There's just things that you absorb living in a household with lawyers that you wouldn't know otherwise, CEG clueless. But I know a lot about like aviation through my mom being a flight attendant. I learned a lot about people through my parents. But lawyering, there was a different level of knowledge with people who grew up with lawyers around frequently. Law is also a very connected field. Rachel, we're getting to court just after this. I wanted to read this first because I don't know if it's going to come up in court. And I saw the title and who was subpoenaed, and I was really interested in the tea. So I decided to do this one first. It's like, and Jeanette said, my dad, his brothers, my grandpa, and his brother, 5 of my cousins have engineering degrees, right? Right? Dentists tend to do that too. Dr. B was one of the first on like his direct line to go to college and get a professional degree. My mother-in-law went to college a little bit later in life and was very successful in what she did. But Dr. B was the first kind of professional in that way in his family. And then you're working with dentists who are like, my dad was a dentist. My mom ran the office. My uncle's a dentist. There are some professions where you just trickle down. A lot of you are saying teachers too. Not my family. My dad took one look at me and went, teaching is probably not for you. You really don't have the patience. But you get exposed to the things that you know and can kind of choose, oh, I want to do that. And then you know people, and then you know all the people, right? So what have I created? I've created a 13-year-old that wants to be a YouTuber. That's what I've created. It's not going to go well. I love this. My parents are engineers. They said not to be an engineer. Lol. Extended family add up of teachers, cops, and attorneys. My mom was a librarian. I was not going to be a librarian until I was. Look, teaching is something I liked. I feel like I get to do it my own way now. I feel like we're kind of adjacent to it, right? But no, I did not have the patience to be a high school teacher. Correct. I did not. Law school, maybe. University, maybe. I was a good swim instructor. I taught the best aqua aerobics, but I did not have the patience to be a high school teacher. I definitely didn't have the high school patience to be a middle school teacher. Those kids will make you cry, man. Middle school is fucking terrifying. All right, continuing on. The attorney has said, Your Honor, the word is shall. Shall impose sanction. Sanction. Mr. Skordas has now had to spend considerable resources in objecting to this overly burdensome subpoena. Well, we're glad you did, Mr. Skordas, because who would have thought that anybody even would have subpoenaed all this shit? It's wild. So I'm glad you did. Oh, I have to save this about the beaver dentist. Hold on. I'm holding on to that. Skordas would not have to waste their time on this dumb shit. I'm paraphrasing now. If the lawyers had just limited the subpoena to shit that they can get and not shit that they can't get that's privileged. The issuing attorney has thus failed to take any reasonable steps to avoid imposing an undue burden and expense on Mr. Skordas. And honestly, how dare they? Paraphrasing. As already stated, the issuing attorney did not make any attempt to limit the requested communication and those relevant to her case, despite ample opportunity to do so. The issuing attorney could have requested the privileged information. The issuing attorney could have requested the privileged information requested be subject to review. That's also a wordy sentence. We can go with simpler sentences. subject to review by the court to determine whether any privilege applies before compelling production. But she did not do so. You could have asked this go to a taint team. Because the issuing attorney took no reasonable steps or care to avoid imposing an undue burden on Mr. Skordas before serving the subpoena that was overly burdensome and which required Mr. Skordas to expand legal resources to object to the improperly issued subpoena, the issuing attorney must be sanctioned and deemed appropriate by this court. Hey, Your Honor, fuck them. This ain't cool, man. Mr. Skordas has submitted a request for hearing with this motion to determine the merits and award sanctions and attorney's fees. Ethical duties. Defense counsel's conduct violates the rules of professional responsibility, namely 1, Rule 3.4, C, disobeying procedural rules, 2, Rule 4.4a, using means that burden third persons, Rule 8.4d, undermining the administration of justice. The court is not going to report the defense attorneys. The court is going to be like, can we modify this subpoena? Also, what are you doing? Prayer for relief. Your Honor, make them pay. Request for hearing. I'm so in on the request for hearing. Do it, do it, do it, do it. The defense hasn't responded to this yet. This was filed on July 8th, 2025. So we're a month out. And I have seen no response. But I want to know if this hearing is going to get set. So with that, I wanted to see if this would come up in the scheduling in this court hearing. We have not watched yet. This hearing is from Monday. So I'm going to put up our live court replay because yes, it's live court, but it's not live this freaking second. I am very glad that the media went, oh, hey, we should make a request. Because again, there's things I won't think to request. I am recovering from people pleasing. So I'm like, I don't want to bother you. I need to get a little bit better at bothering people, but like, I don't want to bother you. It's fine. But I'm glad they made a request to record the Zoom. I was on the last Zoom hearing and just took notes and relayed it to you. And then Law and Crime was like, can we just record it and share it later? And the court approved it. So I'm glad that they did. I'll just do that next time too. Alrighty. Are you guys ready to go to court? We already flew to court. This is a Zoom hearing. I'm turning on closed captions. I'm going to do my best that they don't block people. There are a few people in court. So you will see people in court. You will see the judge, but this is a Zoom hearing and I will move myself around the best we can, but I am ready. Nita said, Emperor Palpatine's voice, do it.
Do it.
Sarah said, my dad was a journalist. My mom was an English professor. So as a result, I'm obsessed with correct grammar. It's a good thing to be obsessed with. However, it must be difficult watching language shift. But Attorney Alessi must have just delighted you. Like, it's the kind of thing where you call up your family and you're like, this man is a delight. Listen to his use of language. All right. Are we ready? Oh, we had more gifted memberships. B2, thank you. B2 is now personally determined to break slow mode. Because if you are a member on the YouTube channel, you don't have to wait to enter in comments. Thank you, B2. That's incredibly generous. Rachie71 said, love being a member. Thanks for the safe space. Look, the internet is great for a lot of things, and we can create great places to connect with each other, have a conversation, take a look at things that are hard, acknowledge when they're hard, have a laugh when we need a minute, and also know that, look, at the bottom of all of this, oh God, I'm now one of those lawyers, that underneath a lot of the cases we cover are actually really serious things. But there are things that happen in criminal cases that are ridiculous, and both things can be true, and it doesn't take away from the heaviness of a given case. So I appreciate it. Christine, happy birthday. Lawnards, are you ready to go to court? Are you ready? Are you ready, Lawnards? Are you ready?
Not today, Judge.
I'm ready. And we're never going to not today this judge. Look, he's one of our favorites. Pam said, Dad, federal judge, two brothers, attorneys. look, it happens. You kind of do what you know. But my growing up, my dad was a teacher and then an administrator. My mom was a flight attendant until her retirement. So, look, my mom's stories about being a flight attendant, like back in the day, are fucking wild. Wild. But because there were times that my mom was traveling when my dad was a school admin, my dad often had to work football games. So what does that mean for young Emily growing up? That my dad was like, hey, you're coming to football game with me. Sit with the band. So I've never been a huge fan of football. I've always been a very big fan of band. But I got to spend a lot of my time growing up sitting with the high school band at one high school particularly, but at a variety of high schools. And it really did shape the course of, I think, my life and my enjoyment of music and live music. And I'm going to get all emo about it. I will continue to get emo about band directors. They change lives. Look, teachers change lives. We know that. So band directors have a very special place in people's lives. All right. Are we ready? Look, we need more live music, not less. That's why I get all boomery about AI, because we need more live music. Law nerds, remind me to tell you about my band director's retirement party. When my high school band director met Dr. B. Eric Page in the chat said, I was in color guard for 4 years, still know nothing about football, but I bet you know a lot about drummers. All right. We ready to go to court? Let's go to court together, law nerds. This hearing's about an hour long. I'm going to try to not pause too much. No promises. All right. Let me embiggen myself just a little bit. We're going to just mess with where we're at. I did not attend this hearing because I knew it was going to be mostly scheduling, but also we've got a lot to do before I travel for DCI finals. Michelle, I played the drums, and then switched to color guard. A lot of the chat knows why. Costumes were cuter. No lies. All right. We talked about that in a members only. We'll talk about it again in another members only. There are photos. Are we ready to continue? I know all of you are like, has the judge shaved? Yeah, the judge has full like summer face going. You guys, I told you we were going to simp too close to the sun in this. And that Judge M's wife at some point was going to be like, we can't stream this case because I can't have my spouse with a fucking fan club on the internet. Because for judges, you don't normally get a fan club. I have to wonder. At some point, this judge is going to be like, we can't stream this trial. It's not going to be because of the case. But yes, maybe by February, the beard will be back. I mean, it's summer, it's hot. I get it. But yeah, RIP, the beard that we love. But yes. All right. So what you see on screen is Attorney Bloodworth, the prosecutor, the courtroom, other squares, and Judge M. You ready? Let's go. Emily, you've been saying we're going to court for like an hour. I know. Oh, away we go. This is why we timestamp.
We need. We're on the record at 231-500-139. State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances, please?
So the judge is in court. The audience is in court. Some of the prosecuting attorneys are in court. Mr. Bloodworth is by Zoom and not in court. And then we'll see the attorneys make their appearances. For everybody's like, oh my God, judge voice. Continue on. I know the interviews Emily would love to do. Judge M, we would like to know more about you. Did you ever sing a cappella in college? We have so many questions. It will never happen. Continuing on.
Good afternoon, Your Honor. Brad Bloodworth, Lindsay Shervanack, and Fred Burmester for the state.
Hello, Attorney Bloodworth.
And, Ms. Nestor is caught on the attendees list. One moment. Okay, my apologies.
Miss Nestor's like, can we get to
Counsel
court?
for Ms. Richins, please. Oh, you are muted. Let's fix that.
All right, thank you.
That's
Wendy
so
Lewis, Catherine Nestor, and Alexander Ramos for Ms. Richins. And I believe she's
All right.
present on
Shit.
WebEx.
And let me just confirm. Ms. Richins, can you just confirm that you can hear us okay? Give me a thumbs up if you can hear okay.
Oh, hold on. Let me move. I have to. All right. This is probably the only time we're going to see Richins in court. I know WebEx is worse than Zoom.
All right,
Ah,
very good. You're welcome to turn your video off if you'd prefer. I'm going to mute your connection just so we don't pick up any unintended
she immediately
background
turned
noise.
off. Immediately turned off
All right, counsel,
her.
we've got several
WebEx call.
scheduling issues to discuss. First, Mr. Bloodworth, I think
Sorry, Attorney Nestor.
it would be helpful
I
for
hate
the
WebEx
state
too.
to file an amended information that reflects the dismissal of what was previously numbered as counts 3 and 4 and the severance of what was previously numbered counts 5, 6, 9, and 10.
Here's what
Any
happened.
objection?
So early on in the case, the prosecution had filed 2 counts of possession with intent to distribute narcotics. I didn't like those counts at all. They dismissed them, not because I didn't like them, but I didn't like them. It was pretty clear to me that the theory of the state's case was that Kouri Richins obtained illegal narcotics for the purpose of committing this crime, not because she was going to start selling it to people. So I just think it goes against the intent of the law, and I think it's kind of silly. They dismissed those 2 counts. Then the judge on the defense motion, the defense won their motion to sever some of the counts out. Some of the financial counts, the court said, were too distant. And so with those counts being more distant, the court severed those out. So the judge pulled out the older financial crimes. So some things will come in as motive and context, but not all of it. The full thrust of the financial stuff will be a separate case. And that filing we went over a little bit ago with the 20 whatever new counts. But I did not love those counts. I thought they were just kind of silly. It's just not what the law intends, right? You're not, if somebody procures illegal narcotics for the purpose of poisoning, they're not really intending to distribute. And yes, somebody could say you're intending to distribute it to the person you're poisoning. Fine. Charge them with murder and attempted murder. The distribution is just not really what is meant.
Action.
So the court has asked the prosecution to file an updated complaint for that.
Any objection?
Mr. Blower's like,
No,
what?
no objection, Your Honor. We can do that too. We can also probably address the redundant charging between the information on the aggravated murder and the recently filed information involving some fraud as well.
Okay. And is that something that you address
Sorry,
through?
Ms. Nestor.
Well, let me take a step back for a moment. My apologies. My anticipation was that
Keeps moving, so I'm trying to move too.
or that contemporaneous with that amendment, a new information reflecting 2 counts of mortgage fraud, 2 counts of forgery from June and August of 2021 would be filed, and that court staff would backdate that information to match whenever those counts were originally filed in this case number. Do you see it differently?
Your Honor, I apologize. I'm not following.
So as it sits today, the most recently filed information in this case has 11 counts in it. 2 were dismissed without prejudice on November 12, 2024.
Yes.
And on the same day, the court made some rulings regarding joinder and by implication severance. And those rulings separated, for the purpose of the upcoming trial, counts 5, 6, 9, and 10, which are mortgage fraud and forgery based upon events alleged to have occurred in June, of August, and 2021. Those counts need to be severed from the operative information in this case. But the filing date needs to be backdated so that there's no statute of limitations problem.
I understand, Your Honor. Those counts, 5, 6, 9, and 10, are also included in the recently filed information.
Your Honor, you can't.
Involving Ms.
What are you doing? You're going to kill us all. We can't handle it. Your Honor, we are not mature. You can't. Emily, did you pause so you could back it up? Yes, I did. Yes, I did. Yes, I did, sir. Emily, why are we watching a status hearing? This is why we're watching a status hearing. Also, the judge is like, don't you need to file a complaint that encompasses these severed claims? Because those claims aren't going to trial and you want just one kind of clean complaint or information to go forward with the jury. So the counts that are going to trial are together. The counts that are going to trial later are together. And he's like, no, those are encompassed in the new indictment with all of the fraud charges. So only some of the background is going to come in the murder trial. Much more of the background is going to come in that fraud prosecution. I don't remember what day I covered it. We'll link the whole playlist down below, but that was A, quite a lot of tea, and B, it is, I'm looking at it real quick right now, 26 additional charges. Sorry, Your Honor, what were you saying? What were you saying? You were saying get in the car, Elizabeth. I'm sorry, what? We're going to go back up real quick.
Alleged to have occurred in June, of August, in 2021. Those counts need to be severed from the operative information in this case. But the filing date needs to be backdated so that there's no statute of limitations problem.
I understand, Your Honor. Those counts, 5, 6, 9, and 10, are also included in the recently filed information involving Ms. Richins and some other fraud counts as well. So the state will, in essence, dismiss them from the current information because they are charged in the new information.
Now I understand. My apologies. Okay. The newest filed case, criminal case against Ms. Richins, I have not seen a summons and I have not seen a warrant. What is the intent on that?
Yeah, what are we doing? There's nothing on it.
Your Honor, summons, and I
just
apologize. I thought it was
sitting.
in the information. We can fix that.
Okay.
But it is summons. The state had figured the court would, based upon summons, I guess, conduct an initial appearance and appoint counsel today. But if we can get a summons and do that next week.
Paperwork. They need to do
Ms.
paperwork.
Lewis, have you and Ms. Nestor and Mr. Ramos had a conversation with Ms. Richins about whether you'll be appearing on her behalf in that new case?
They would have to be
Well,
appointed.
we'd have to be asked by the county to do that,
Right,
and
they'd have to be
nobody has
appointed.
asked us to do it yet, so we didn't know what was going to happen with that. We're willing to do it, but
Iritas asks, how did the two women not react to the judge going, I'm swooning? They're in work mode. They're just in work mode. They're full work mode. So work mode just kind of shuts off everything else in your brain, I have found. So that. But the court is saying, hey, and they say we have to be appointed. There's a process for appointing counsel. And so they're saying we have not been appointed on Kouri Richins' new case. Again, on June 27th, the prosecution filed that 26 count fraud indictment separate and apart from the murder or information. I don't think they indicted her. It's an information. There will be a prelim. But what's probably going to happen is that case will get attorneys appointed and then it'll just trail behind the murder case and nothing will happen on it until after the murder case. And the court could, if he wanted to, set bond on that case because she has no bond in the case she's on. He could set bond in that case or not. So, all right, let's continue. So the defense is saying we haven't been appointed yet.
Yeah,
But I mean, if you
typically,
appoint us, we will, but
Jenny Young reaches out to me if she wants us appointed or me
But we
appointed
haven't
on
been
something,
appointed.
and that hasn't happened.
so if they appoint us, we'll do
I
it.
know it is. We have conflict counsel now. I don't know if the contract has changed.
I think the court is talking to his court assistant because that's where the court assistant would sit.
No, but the prior contract didn't include capital charges. Folks, this is not something I'm supposed to be getting involved in.
No, how people get appointed is not your problem.
I'll
This is
ask
not a
Brittany
you
to reach
problem.
out to understand what the current contract with conflict counsel looks like as it relates to the charges that are in the most recently filed information. And hopefully Ms. Young can provide some clarity. Okay.
Your
Bottom
Honor,
line, Mr. Bloodworth, I don't
This
have
is
a summons yet,
logistics.
so I'm not in a position to hold an initial appearance.
Logistics. And
I
there's no
understand
attorney.
that, Your Honor. We'll address appointment of counsel, I guess, once the court holds an initial appearance. But to preview matters, it's the state's view that it would make sense to appoint Ms. Richins' current defense team, considering the overlap
Okay,
in
you don't get a say in it. It's
discovery
logical.
and information, that kind of thing.
Sure, it's easier for
Okay.
everybody, but it's not really your choice.
Perhaps someone from your office can transmit that view to Ms. Young.
Yes, Your Honor, we can probably do that. We try to stay out, as you can imagine. We try to stay out of the appointment of counsel.
Yeah, you don't get to
business
pick
as
your
well.
opponent,
Yeah.
right?
Okay.
You don't get to
We'll
pick
take
your
this one
opponent.
step at a time. In case ending 139.
This is all administrative. How defense attorneys get appointed from the list because they're conflict counsel, because other attorneys were conflicted out, but how appointments are made and who is a whole different thing. And then the rates are probably different too, because they're appointed on a murder case. Getting appointed on a fraud case is different. And some attorneys will be approved for appointment on a murder case and some will not be approved for appointment on a murder case. So normally you would get a different maybe appointment on a fraud case, but it's same defendant. So you kind of want to stay with same attorneys, et cetera, et cetera, et cetera. But they might say, no, we're not appointing the same attorneys. So it's really a lot of logistics work that no one in this scenario has control over.
If the state would please
This
file
shit needs to happen.
an amended information that includes only counts 1, 2, 7, 8, and 11 as the counts going to trial in February.
Sure. Makes sense.
Yes, sir.
Good.
Okay. Ms. Lewis, anything further on that?
No, Your Honor.
That's all regarding the new
All right.
indictment.
I circulated today a copy of the juror questionnaire that we had previously sent to potential jurors in March. If you all would re-review it, compare notes, and then let the court know whether you propose any changes to it.
They have to
Can you
compare
send me
notes.
though a response on that issue by September 5, Ms. Lewis?
Yes, that'll be fine.
Mr. Bloodworth?
Yes, sir.
Ms.
We
Shervnak,
won't
are you
see
handling
those.
that issue again?
Probably.
Okay, September
Yep.
5. All right. You can do it by email, or you can file stipulated something or competing somethings.
Oh, if they file it,
I
we'll
just
see
need to
it.
get those to the jury team so they can start getting ready.
The juror questionnaire
Okay.
will be sent out
Anything further?
generally with summonses or after summonses are responded to. So they need to start preparing for all of that to go out. Because again, this is a lot of logistics, and so much of court is sitting around talking about logistics.
On that, Ms. Lewis?
No, nothing from us.
Ms. Shervnak?
No.
Okay. One moment, folks.
So the court is checking probably dates. For those of you asking when is trial, February 2026 is when this will go
Just to
trial.
review
And I
and
think
make
it'll
sure
probably
that we
go
don't need to make any changes.
that day.
We'll send the questionnaire to 2,000 Summit County jurors. Council will receive the completed questionnaires, as many as we get back, by. Okay.
By when? Oh, it
Anything
looks like
further
it
on that,
glitched
Ms.
a little
Lewis?
bit.
No, nothing from us.
So 2,000
Shervnak.
jury summonses are going out.
One moment, folks.
This all, yeah, it jumped a little bit. This all has to be decided now, because between now and then,
Just to review and
Takes
make
quite a
sure
while.
that we don't need to make any
Well,
changes.
there's a lot that needs
We'll
to
send the
happen.
questionnaire to 2,000 Summit County jurors. Council will receive the completed questionnaires, as many as we get back, by January 20. February 2nd, 9:30 a.m. in person. We'll hold a hearing to strike jurors for cause based on questionnaire responses and council's review of questionnaires. And then we are scheduled for attorney-conducted voir dire over up to 6 days, February 10 to 13, and February 17 to 18.
That won't be aired.
2 session each day, 8:30 a.m. to noon,
So that we will
and
not see
1
that
p.m.
part.
to 4:30 p.m. each day. It will be 20 jurors in the morning, 20 jurors summoned for each afternoon, and it takes as long as it takes to pass 24 jurors for cause. Ms. Shervnak, you're furrowing your brow.
Why 24?
It's a jury of 8 plus 4 alternates by previous stipulation. And then 8 peremptories per side.
Oh, I see.
No, sorry,
80?
8 peremptories total.
You're
8.
talking about how many to
8 peremptories. Holy shit. So you heard that correctly. I'm going to back that up one more time, but you heard that correctly.
Ms. Shervnak, you're furrowing your brow.
Why 24?
It's a jury of 8 plus 4 alternates by previous stipulation. And then 8 peremptories per side.
Oh, I see.
No,
Clear.
sorry, 8 peremptories total.
You're talking about how many to clear. I see. I thought you were talking about seating 24.
No,
I
sorry.
understand.
24 passed for
I just
cause.
misheard you.
And I want to make sure
The court is talking about the jury. They are seating 8 jurors. So they will be seating 8 jurors with 4 alternates. Because in Utah, you only get 12 if it's a capital case. And though this is a first degree murder, it is not a capital case because they are not pursuing the death penalty in this case. So 8 jurors will deliberate the case, 4 alternates. So when he said 8 peremptories, I thought he said 80 peremptories. I was like, holy fucking no, 80 peremptories. 8 peremptories, which makes sense because you're seating a jury of 8. Peremptories mean you can yeet a juror for vibes. You can just, any lawful purpose, you can yeet a juror. But kicking for cause, there's no limitation to that. And they're going to kick for cause on the questionnaires first. If somebody signed a questionnaire was like, hey, I'm a law nerd. I literally know everything about this case. They're going to just get kicked for cause, and they're not even going to get called in to come into the courtroom. All right. So let us continue.
Didn't 8 jurors plus 4 alternates plus 8 peremptories per total for a felony case plus 2 additional per side given the additional alternates.
Yep.
Okay. Okay. Ms. Lewis, any comment on that?
Not at this time. No.
Okay. All right.
Sorry, Mr. Ramos. He's down in the corner where my
Then
face is.
I listened to the last pretrial conference that we had in June. I asked counsel to meet and confer regarding some potential hearing dates to hear motions that have already been filed,
There are a
including
lot
an
of motions.
evidentiary hearing on defendants.
There are a lot of motions still pending. There's a motion still pending on the walk the dog letter and more, but there's a motion still pending. So the court is trying to set up all of the different dates they need and the deadlines that go with those dates.
Motion to exclude state's expert witnesses, which is fully briefed. And then also to come up with some filing deadlines and a potential hearing date for the forthcoming defendant's motions in limine, which Ms. Nestor previously described as substantial. So what have you all come up with?
The court's like, what is substantial? Y'all had like 2 months to meet and confer. Why is everybody so silent? Why is everyone so quiet? Y'all were to meet and confer and give me a list of dates. What have we come up with? What are we supposed to be doing? And everybody's just like, well, y'all were supposed to have a list of dates. That's it. A list of dates for when to do all this. And the court's like, what have you come up with? Nobody said anything.
The state has said whatever we said is fine with them. So we didn't really come up with anything specific, but how far in advance do you want to set?
He wants them today. The court said he wanted them today. The prosecution said, I'm good with whatever you choose. Pick your dates. And the defense is like, so we didn't do that. All he asked for was for you guys to put together a list of dates. And the prosecution said, whatever dates you pick are fine. Because both defense attorneys have a couple trials between now and then. And they just didn't do it. This is why judges start getting frustrated with attorneys. We are having this hearing today for you to tell me your dates. You have 3 attorneys that are going to be in different trials. The prosecution said, we're here regardless. And y'all went, so my bad. Oh my God.
Substantial. So what have you all come up with?
You knew this was coming. This is exactly what he said at the last hearing.
The state has said whatever we said is fine with them. So we didn't really come up with anything specific, but how far in advance do you want to set these? I mean,
today. He wanted to know today what your
we
dates
can just
were.
get them set now.
Look at his face. He wanted to know today. He's like, I wanted you to have an answer today. Today was the day. I want
All
you
right,
to.
let's do this one at a time. The evidentiary hearing on defendant's motion to exclude the state's expert witnesses. Is that half a day? Is it a day?
Have we not thought about this since the last hearing? No, we
I would
haven't.
think we could do it in a half a day.
We
I don't
haven't.
know. Do you disagree, Kath?
They haven't even talked about this since the last hearing because now they're conferring about it on the WebEx call. That's why the court said, y'all do this before you come back to court. Because now we're going to spend half the hearing today with the 3 defense attorneys going, how long do you think we need? What day works for you? Y'all could have done this over lunch. The court's like, fine, we're going to have to go hearing by hearing and figure it out. So we're here. And the prosecutor is just like, just tell me when we're done. So frustrating. This is why judges start to get snappy with attorneys. Because if you do this for every single case, day after day after day after day, eventually you're just like, I am no longer patient.
See,
I think it's
Or
gonna
Brad?
take a day. I think
you
it's
think
gonna
we
take
need a day?
I agree. It's a day.
This could have been an
It'll
email.
be two
All right.
experts. I think a half day apiece.
And Mr. Bloodworth, I recall asking this, but I can't recall the answer. It's two experts that have been challenged, the profiling expert and the domestic violence expert. Is that correct?
Correct.
Correct.
Handwriting expert.
And Mr. Mr. Throckmorton. Okay, so three experts: profiling, domestic violence, handwriting.
Handwriting.
Mr. Throckmorton has
Bold.
produced a written report. Is that correct?
That is correct, Your Honor.
The domestic violence expert, has that
The type of hearing they're talking about is the type of hearing we saw in the Reed case when there were challenges to the experts. That's the type of hearing they're talking about, putting the expert on the stand and having a chat. So continuing.
person produced a written report setting forth their opinions, or is it a summary that's been provided by the state?
Your Honor, the state's provided a summary, a proffer of their testimony.
Okay. And then the same question regarding the profiler.
The state's provided a summary of their testimony, again, a proffer.
Okay. All right. And forgive me, did those three productions include the CV for each expert?
Yes, Your Honor, it did.
So
Okay.
look, discovery's been turned
All right.
over.
So we're talking about three experts over the course of a full day. Is that right?
Look at that. All the discovery's been turned over.
Yes.
Yes.
Okay. All right.
The court is like, we are going to be efficient, we are going to be expedient, and we are not going to spend a full day per expert. No. Ask them the questions you need to ask and get out. The court's probably looking at dates because nobody proposed any dates.
Counsel, let me ask a categorical question. Do you feel like we need to handle any of these issues prior to January, or can I just plan to spend a lot of time on this case in January?
I don't think we need it before January, Your Honor.
Mr. Bloodworth?
Yay, Judge. We're going to be together in January. Happy
Your
New
Honor,
Year,
I
everybody.
think early January would work.
Okay.
Mr. Bloodworth is so chill. He's like, whatever the defense wants to do, it's fine. We go to trial. That's what I do. Whatevs. This isn't hard. Also, it's easy when the attorneys trust the judge.
All right, let's begin with this expert
Whatever you
witness
want to do,
issue.
Your Honor.
Ms. Lewis, Ms. Nestor, during the week of
And now we have
January
to check
5,
17 different calendars.
are there days that are preferable?
Kathy, I'm open that whole week. Alex, what do you guys have?
If we could avoid Friday the 9th, that would be great. But other than that, I'm open the whole week.
Okay. I don't think we have a calendar.
2026 calendar.
I know we don't have it. I don't think we have a calendar on the 9th, but that's irrelevant.
So now everyone has to check their calendars, including the court calendar.
So maybe the 6th or the 7th, since that will have been right after the holiday weekend, maybe avoid the horrible Monday and do it like Tuesday or Wednesday.
The horrible
or
Monday.
Thursday.
Well, and then tell me, should
We
we
hate the
block
Monday
2
too.
days in a row?
Yes,
Should we do the
Yes, you
expert
should.
issues one day
Yes,
and then
you
hear
should.
oral argument on
you 100% should.
the walk the dog letter, the 404B evidence,
Yep.
and defendant's motions in limine on the second day?
Yes. Yes, you should.
I don't know that we may not be ready to do our motions in limine yet.
Too bad.
Oh,
Your
yes,
Honor.
we will. Yes, we will. Yes, we will.
Lawyers are like goldfish, Your Honor. Give them a container. They'll figure out how to fit it. Just give them a date.
By January, yes, we will. Yes, we will.
Yeah, the trial
Is
starts
that
at the
enough time if
beginning
I
of
put all that
February.
stuff together?
Uh-huh. Yes.
Okay. Mr. Bloodworth, any objection?
No, Your Honor.
He's like, we're chill.
So may we block January 7 and 8 for those purposes?
Sounds great.
So we're doing 7-8, not 6-7.
Yeah. I'm going to need the 5th and 6th to get ready.
Yep.
That works for the defense. Your Honor, I just want to make sure I'm clear, though, since that's a full month prior to trial, if something should come up between then and trial, I just want to make sure that I still could file a last minute motion in limine if I need to. But I mean, I will.
He's not going to
vast
jam you up.
majority,
This
I will
judge
know
is
by
going to
then,
ask
no
for a
problem.
reason.
I understand. I think Mr. Bloodworth is likely to ask for the same reasonable accommodation for his team.
This
Right.
judge is not going to jam you on stuff if you've done your work
Yes, sir.
reasonably and all the discovery's been turned
Okay,
over.
let's
They
block
have what
January
they need.
7 and 8
Let's do it.
for in-person hearings on the following. On January 7, we will handle defendant's motion to exclude state's expert witnesses. That's docket 883. Let's begin at 9:30 a.m. that day.
That's
Then
local time to
state's
Utah.
motion to determine admissibility of the walk the dog letter, which is docket 913. State's first
Wait.
notice of intent.
The admissibility of the walk the dog letter is docket 913, but the walk the dog letter itself is what, chat?
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Let's see if the judge changes his mind on streaming between now and then, because the judge has not allowed streaming of this case, and we've had to do it on like a day or two delay. Let's hope that between now and January, A, the beard is back, and B, the court's like, we can just watch it together. Right? Fingers crossed.
Offer for Rule 404B evidence, docket 865, and then defendant's forthcoming motions in limine will be addressed on January 8,
You might not get to all of that.
beginning at 9:30 a.m.
Optimistic.
Thank you, Your Honor.
Ms. Go ahead. I'm sorry, Mr. Bloodworth.
The state will, well in advance of them, file its second 404B disclosure. I suspect we'll want to address both at that time.
What's a reasonable filing deadline for the second one?
If you want to know what it's like to be a lawyer, this is a lot of it. People
Your Honor,
staring
how
at
about
calendars
a
going,
month out, so
shit.
whatever, December 8th.
September 5.
no, December.
I didn't know if you meant a month out from.
Oh,
I'm
I'm sorry, a month back.
A month back from
You will,
January.
yeah, that'll have defense counsel briefing during the holidays and maybe you all as well. It's a boy. Can we do a little earlier than that? Can we say 6 weeks?
That's very kind,
Yes,
Your
sir.
Honor. He's
All
like,
right,
we don't want to brief over the
let me look at my
holidays.
calendar for a moment.
Let's have some life balance. Let's do that a little sooner so we can all just take a breather, be well rested before trial. We don't need anybody being snappy.
Yeah, why don't we say November 26th?
Yes, sir.
It just is so normal. It
And
just
then
moves on right along.
Ms. Nestor, Ms. Lewis, can we agree defendant's response to the second notice is December 12 reasonable?
It's fine.
Yes, sir.
These are
Okay.
just filing deadlines. So
And then to the extent the state wants to file a reply regarding the second notice, let's just say January
Sorry, Mr. Ramos.
31.
We're just here. You're not going to be able to see
You mean
Mr. Ramos
December
anyway.
31?
I meant December 31.
December 31?
My apologies. December 31. All right. Okay. Ms. Nestor, we need to come up with some similar deadlines related to defendant's forthcoming motions in limine. What sounds reasonable?
He's very considerate of the attorneys in his courtroom.
Do you want us to just follow that same briefing schedule? I mean, that'd make it simpler.
We can. Works for me if it works for you.
It does.
Mr. Bloodworth?
That works, Your Honor.
Okay.
They're all already
So,
going to be working on this.
The deadline for defendant's forthcoming motion.
This is literally half of being an attorney, but they're all going to already be working on this. So they're like, no, by January, we're already in trial prep. So it just makes it so easy to go through and just be like, yep, same deadlines. We'll get everything done. They're just, yeah, we'll get it filed. We'll get it handled. It's very normally the way court should work. And then the attorneys go through and mark in their calendar how much time they think they need to prep it and work backwards from these dates.
Motions in limine is November 26. The state's response deadline is December 12. The defendant's deadline to file a reply, if any, is December 31.
And then, Your Honor, the state may have some motions in limine as well. We'll follow the same schedule.
He's like, we'll do the same thing.
Okay, very good.
Look at how easy the scheduling is working.
Okay. All right.
I mean, just to keep, not to beat the dead horse, but I think our exhibit and witness list would be due like 30 days before trial, which would be after my motion in limine filing deadline. So obviously if they file exhibits I'm not expecting, I mean, we'll just file them as soon as we are aware.
I imagine.
Haven't we seen exhibit and witness lists already?
No.
We've seen a
Could we
preliminary witness list.
I don't imagine anything's going to be a surprise in this case. I could tell you what I mean, maybe there will be, but I could tell you what I think the state is going to bring in. The state is going to bring in the digital evidence, the text messages, the walk the dog letter, the journal that we've heard so much about that we haven't seen. I just imagine this in my head to be like, dear diary, the news says that when people get around fentanyl, they die. Yet I had to actually ask for more. We kind of know what the evidence is, and they've had the discovery for quite a while. So it's really where the court's going to limit the 404 on the financial crimes. That's really what we're looking at. But I don't think there's going to be anything that's a surprise. You already have all the discovery, and I think they can probably guess.
But no exhibit list in the
But I want to see the journal.
We gave some
Right, the
witness
only
lists
thing we
in the
saw was,
questionnaire,
right.
but we haven't filed our formal disclosure.
Understood. Why don't we just set a much earlier deadline? Wouldn't you rather see that before you're filing motions in limine?
Wouldn't it be better if we all do a triple?
No.
Yes, well.
Can I see theirs?
That's what I was going to say. We'd like theirs, but we don't want to file ours yet.
I'm going to back that up. The defense being so for real. Well, we'd like theirs, but we don't want to file ours. Can we just get their list? I think even Attorney Bloodworth might have smiled on that one. I'm going to rewind that because I started laughing too quickly. And then I overlaughed the judge's laugh.
We
saw
saw
a questionnaire,
right.
but we haven't filed our formal disclosure.
Understood. Why don't we just set a much earlier deadline? Wouldn't you rather see that before you're filing motions in limine?
No.
Yes, well,
Can I see theirs and not show them
that's what
mine?
I was gonna say. We'd like theirs, but we don't.
One defense attorney says no. The other defense attorney says yes. And the judge goes, what? Look, you can tell that everyone's just working together fairly well in this case. Even Attorney Bloodworth smiled. It just is what it is. I will say there are times where I'm sure defense attorneys can tell these stories better than I have, but there were times when we would have a lighthearted moment in court, the prosecutor, the defense attorney, the judge, or whatever it is, and defendants would get so frustrated. I don't get that sense from Kouri Richins, but there were times that defendants would just get so frustrated because they would be like, look, you're all laughing with the judge. You're all out to get me. It's like, no, the judge is like, I just got the exact opposite answer from each attorney. That's hilarious. But there definitely would be cases where there would be a moment in court and the defendant would get fucking pissed. So it's funny. It's funny to me. All right. The judge being like, what are you even saying? I'm backing it up again. Look, I like it when court goes normal. Not everything has to feel like it's the end of all jurisprudence. So for those of you just popping in, the attorney at the top here, hopefully you can see my pointer, is one of the defense attorneys. Mr. Ramos is behind me and behind the law and crime logo. He's like in law and crime, like jail down there. I can move me, but I'm going to leave me there. But he's in like, he's just in jail down there anyway. So I'm leaving myself over his face. Then as we're Brady bunching ourselves along, we've got prosecutor attorney Bloodworth, and then the other defense attorney, Miss Nestor, and then the judge, and then two of the prosecutors, and then probably media in the courtroom observing. Let's continue.
No.
Yes, well,
Can I see theirs and not show them
that's
mine?
what I was gonna say. We'd like theirs, but we don't want to file ours yet.
I wanted the latest possible date to file my witness list, please.
Right.
But exhibit lists, I don't mind doing in advance, I guess. I don't know.
Because the defense wants to limit the amount of time that the prosecution has their witness list in case there's witnesses on there that the prosecution doesn't know about yet. So they're like, no, we want the last possible date. We want theirs before our motions eliminate, but we don't want to give them ours. The prosecution has already figured out who your witnesses are going to be.
I'd like
I
a
don't know,
late date on that too.
I guess we should think about that.
Okay. Mr. Bloodworth, I have a sense that you have a pretty good idea of
Mr.
who is on
Bloodworth.
your will call and may call list and what's on your exhibit list. Is it possible for the state to file a list of will call and may call witnesses and your exhibit list?
That's the witness list.
Bear with me.
He's saying will call and may call, like these are the witnesses we're calling. These are maybes. So order of priority, which not every jurisdiction requires attorneys to do.
By October 31.
Halloween?
Your Honor, it is possible, but these filings are designed to be reciprocal.
Well, only one of you has the burden of proof, though. And so I imagine who they're calling is going to matter depending on
Who you're calling.
who's on yours and what's on yours.
Who's on first. But
And the burden's not reciprocal. And so I think
I appreciate where Mr. Bloodworth is coming from. He's like, Your Honor, these filings are reciprocal. If we're giving ours in October, they should give theirs in October. And the court is like, so yeah, I get it. But like, you have the burden of proof. Just give them your witness list. Okay. The burden of proof's not reciprocal. Just theirs are all going to be responsive witnesses.
there's some value in staging them here, given the briefing deadlines.
Which is fair.
If the court orders it, the state will comply.
The state doesn't agree.
I think
but
this
they'll
would
do
help
it.
move things along efficiently.
Also, the state's witness list
Yeah, so October 31, states will call, may
going
call
to be
witness list
generally
and
known.
exhibit list. Understanding that in the run-up to trial,
It may
amendments
change.
happen.
Yeah, it may change. But the judge is like, just don't fuck around. You probably already know who your must call witnesses are, law enforcement, the coroner, etc. So
Now, Ms. Nestor, you're going to have to commit to a deadline of some kind.
you have to
What's
turn
your-
yours over too, Miss Nestor.
February 20th?
February 20th is after the trial start date. Right? And the defense is just like, well, we don't want to give him a witness list, Your Honor. Can we do it after the state starts their case? Now they're just trying to tease the court. I think they just want to make him laugh again. Ladies, are we just trying to make the court giggle at this point? It's not just the law nerds. Now they're just trying to make the judge laugh.
To a deadline of some kind. What's reasonable?
February 20th?
Well, I think the rules provide for 30 days prior. So if we want to do it, 45 or 60 days prior, I guess. But
I think the rule is 14 days.
Yeah, I think that's right.
Well, then 14 days. That works out great.
Oh, hold on.
And again, did you notice what happened? Look at what just happened. Mr. Bloodworth is not giggling. He's like, it's fine. She said, I think the rules are 30 days. 30 days is a longer window. I think the rules are 30 days. And Mr. Bloodworth said, well, actually, the rules are 14 days. Most prosecutors that we have seen in a lot of jurisdictions would not have stepped in and said, actually, it's a shorter deadline. Let's just be for real. Would Brennan have stepped in and said, actually, it's shorter than that, knowing that what they want is shorter? Bloodworth's like, no, that the rules are 14 days. It's nice to see a normal, professional, respectful case. It's how it should be. And we've seen a lot of fuckery. So it's nice to see lawyers lawyering professionally. The judge has been firm with the parties, but he's incredibly respectful. And he just keeps things moving along. And everyone does their job as an advocate, but they work together when they need to. It's nice to see.
I'm thinking of federal court. I'm sorry. It is 30 in federal.
Wouldn't it be better if we all do 40? And Mr. Bloodworth's like, I don't care if you're in federal court. That doesn't impress me. He's like, this could have been an email.
February 6th.
Okay.
Ooh, that's right as trial starts. Like right as trial starts.
Yeah.
Thank you.
Let me write that down.
And obviously, we are not producing on our exhibit list anything we're going to use solely for impeachment, only what we're introducing in our case in chief.
I think the state's probably applying the same rule.
Yeah.
Which is different than Massachusetts, which I had pointed out was fairly odd to me. In Massachusetts, they were required to disclose the impeachment, but in most jurisdictions, if it's solely for impeachment, you do not have to disclose it, which means you can't bring it up unless it's for impeachment. Trial starts jury selection. Common Internet Lurker, trial starts jury selection February 10th. But the case in chief and opening statements don't start till February 23rd.
Okay. All right, let's talk about
Thank
jury
you, Migdalena.
instructions for a second.
Migdalena went through and took out some of the longer pauses so we could move through this in a normal fashion. I appreciate it.
I previously stated on the record that I didn't expect the jury instructions in this case to be particularly complicated, but I may regret that. And so let's
Me saying
come up
it'll be
with
a
a
shorter
reasonable
stream.
deadline for
Me.
you folks to meet and confer regarding proposed jury instructions, and then to file whatever you can stipulate to, and then your requested additional instructions that are not stipulated.
I'll hold this for when we get to questions at the end of the hearing. Yeah.
We don't have to have that nailed down at the start of the trial. I don't have to have decided what the jury instructions are going to look like at opening statements unless there's a particular instruction.
It's just better to have an outline of them. They know what it's going to be.
But I need to force you all
to
begin that discussion prior to the commencement of trial. Ms. Nestor, what sounds reasonable?
Well, if maybe we could do it before that 7th and 8th, so that if we spot that we have a big issue, we could just lump it into that discussion with you.
That's reasonable.
That's fine. So here, let's do.
And that's pretty easy. There's nothing. They're looking at dates.
Are you going to be in charge of jury instructions?
There's nothing exceedingly unusual about the jury
Your Honor,
instructions
I'll
in
probably
this case.
handle that.
All right, forgive me, folks, for a little inside baseball here. Mr. Bloodworth, are you trying the Patterson case or is Ms. Shervanek trying it?
The court is now asking the prosecutors about another case in that courtroom. I appreciate the inside baseball. We watch a lot of hearings that are very dramatic. Most of lawyering is this. Let's pick a date. Let's decide when we need to do things. What are we doing? So jury instructions, the court is asking each side to confer on what they're submitting. And if Utah has multiple jury instructions on murder, they might decide or have some disagreement about which murder instruction it should be. But you need, and I always pulled jury instructions prior to the case because you need to be speaking to what the jury's going to have to decide starting with your opening, or you should be. So,
Your Honor, that may be me or Mr. Hill.
They're looking at dates on another case.
Sure that I don't double book you here.
That's considerate.
Mr. Bloodworth, what is a reasonable deadline for the state to send its proposed jury instructions? Don't worry about opening instructions. I just need elements, evidentiary instructions,
right,
the things that would typically be in the closing instructions to the defense.
Not the model jury instructions, just the ones you have to select.
Your Honor, we can do that late September.
It's like whenever you want us to do it.
Okay.
Do you remember?
If you would send your proposal to defense counsel by September 26th.
Oh, we were so close.
October, sir?
He said September.
No, I think September 20th.
I'm sorry,
Yeah,
September 26th. Gotcha.
Is a Friday. If you would send to defense counsel state's proposed jury instructions, and then Ms. Nestor, Ms. Lewis, Mr. Ramos, how about
I know the judge was just trying to pick a
October
Friday.
31 for defense counsel to respond to those proposals with, we stipulate to this instruction or we don't, and here are some additional instructions that we propose.
Okay.
Like the motions in limine, like the witness and exhibit lists, I understand that the exigencies of trial may require the proposal of additional
Things might
instructions as
shift.
trial progresses. But to the extent we can do some of this heavy lifting early,
Wrap your
it
arms
will
around
inure
it
to the
earlier
benefit of all of us.
and then deal with it later. Yep.
All right. Brittany, do you get those two? Okay. No, I'm going to end up doing it live. Okay.
The WebEx keeps jumping around. This is the best
Aside from
arrangement
another
we've
pretrial
had
conference,
so far.
that's everything I had on my list. Mr.
Yay.
Bloodworth, did you have anything else you need to discuss today?
Your Honor, not on this case. We did file the summons in the new case while we've been talking. So if the court wanted to schedule an initial appearance now, if the court's inclined to appoint named defense team.
He doesn't have the ability
there is a
to do
statute
that.
that talks about whom I can appoint,
He can't.
and it requires
do
me
that.
to have information regarding what the terms of the contract with the current roster of conflict counsel is. So I need to build in some time to get that response from Ms. Young.
Right. He said he couldn't
Understand,
do
Your
it.
Honor.
Yeah. If you all would like me to put an initial appearance on the calendar, I can. I can just put it out a couple, 3-4 weeks while we figure that out.
I think we should wait until we know what's going on, Your
Me too.
Honor.
Okay. Very good.
The defense attorneys are like,
We'll get that
please do
information,
not
Ms.
obligate us
Young,
to do things
figure out what I have the
when
authority
we don't
to do.
know we're appointed
and then
yet.
we'll see what happens.
That is all administrative stuff. That
Okay.
just
Mr.
literally
Bloodworth,
administrative stuff.
I interrupted you. Anything else?
No, Your Honor, thank you.
Ms. Shervinack,
No.
Mr. Burmester.
Those are the other prosecutors
Lewis.
in court.
Anything else the defense wanted to discuss?
No, Your Honor.
Well, Alex,
Oh, Alex.
I'm sorry. Mr. Ramos.
Mr. Ramos is in Logo jail back there.
There's two issues that I saw come up as we were preparing for the last trial, and it's more of a practical issue that obviously didn't come to fruition because of the trial date cancellation. But as we were leading up to trial, discovery was continuously produced, and we understand that's something. We also understand that the facts of this case are, in a sense, very much in a silo. We have continued to get discovery, and if that's going to continue to happen, we'd like to request some sort of deadline. Preparing for a case like this, Judge, if it was just the murder case would be one thing. Now with just with the fraud elements of it, it is getting extremely messy.
Some of that's limited.
Extremely difficult to see what's new, what's not.
Your Honor, they filed 26 new counts and it's not matching the vibe. The thing is, some of that's going to be limited and some of that's the 404B notices because there's new stuff with the new fraud counts, but the new fraud counts are related to a new indictment that's not going to be tried at the same time, and they haven't done the 404B yet. Right, I'm moving myself back down. I can't stare at the Logo jail. It's making me crazy. Sorry, Mr. Ramos. We'll record it. We'll just put in a request to record it ourselves next time.
So I would like to try to find a way where we can limit
He's
that.
one of the other defense attorneys.
One. And then the second thing, which is related, Judge, is in terms of the witnesses for the state, the exhibits, one thing that I think would be beneficial and really speed things up is, of course, we get an idea of who they're going to call and maybe what they're going to ask. But certainly having summaries of, hey, witness one is going to testify to
what?
X, Y, and Z, and these A through G exhibits are tied to them to that would be extremely helpful. Otherwise, what I fear is we're going to show up and there's like 40 plus witnesses and we're like, well, yeah, we have the discovery. We know what they said, but had we had some of it, maybe we don't even ask any questions, right? So it's more of trying to streamline the process, Judge.
Yeah, no.
Those are just two things that came up, and I am very concerned that it's going to get worse.
The attorneys will normally break down, this is our general order, but that is subject to shift. I have never seen a court require a witness summary and just a evidence items 1, 2, 3 go to this witness. Some of it's fairly obvious, but no. No.
can I jump on to the back of what Alex just said? I thought he said it very well. I'm not even sure the court is aware of this, but we're at 10 terabytes of discovery in this case. It is the largest amount of discovery I've ever had in any case, and I have done complex.
Your Honor, it's 10 terabytes. You have 3 defense attorneys. And this case has gotten continued and continued and continued. I'm just pushing play. This request is wild. Your Honor, I would like them to give us an outline with each witness, a summary of their testimony and exactly what items of evidence they're going to testify to. No. That would be really helpful. Sure, you have all the reports and you have a witness list. You can do it too.
Fraud I've done. I mean, they've gone back and found every human being that's ever spoken to Kouri Richins, ever. So the concern is, for example, if they're planning on calling like 15 witnesses that are just to create foundations for pictures, I mean, we don't even need them to testify. Like, we'll just agree these pictures are
You can do that
pictures of
pre-trial
what
then.
the house looked like, or what, you know, her childhood home looked like,
You
or
can
whatever
do
the heck they're going to put
stipulations.
in, and save potentially days and days and days of trial. So we're not doing it to add to their workload unnecessarily. We really are trying to determine, you know, are there witnesses that are being called solely for foundation?
Well, they can
that we
talk to you
say,
about
hey,
that.
you don't need to do that. If you're calling them to put in, you know, bank records, we agree to the bank records. You know, cancel one less witness. I mean, this case has become ridiculous in terms of.
Okay, the case is not ridiculous, but that's a reasonable request. It's a reasonable request to say, can we have a conversation about who the foundational witnesses are so that we can just talk about foundation? If you are just calling the custodian of records for something, we don't need that. That is something they can have a conversation about. Sure.
The amount of evidence. And when I say evidence, I don't mean anything that has anything to do with whether she killed her husband or not. I'm talking about just the universe of prosecuting Kouri Richins has become outrageous. So that.
Ma'am, the court separated out most of the older fraud information and limited the dates. It's not outrageous. There's a lot of allegations of money laundering, bank fraud, mortgage fraud, insurance fraud. And then all of those have forgeries connected to them because things are alleged to have been forged. So it's not like the MCU of Kouri Richins. She's just frankly not that important. Also, it's not that big of a fraud case. Truly. Like it's okay.
I guess I don't want it to sound like we're trying to make them give us an unfair advantage. We're trying to eliminate days and days of unnecessary, pointless trial days. So I just wanted to add that to what Alex
isn't
had to say.
pointless. But
So let's break this down a little bit.
yeah, okay.
With respect to a deadline by which the drawbridge will be raised and the information inside the Discovery Castle here will be set, Mr. Bloodworth. I can appreciate why there may have been rolling productions in the past as additional forensic downloads or analysis.
Which is what a lot of this is going to be, is digital
electronically stored
devices.
information occurred, but we should be beyond that point now. Have we produced the discovery that is in the state's possession or control?
Hey, Massachusetts, look how easy this is. Look at how easy this is. At some point, the drawbridge goes up and no more discovery for you. Look at how great. Look at how easy that is. Hey, are we there yet? That was supposed to resume.
Have.
Okay.
Look how simple.
Stored information occurred, but we should be beyond that point now. Have we produced the discovery that is in the state's possession or control?
Have.
We have,
Okay.
is what he said.
And aside from some kind of realization that something got left out, analysis has at least searches and analysis are concluded. The universe has been produced.
It's hard to say, Your Honor. If it relates to some of the 404B evidence, perhaps not. As it relates to some of the more core evidence, if the court will, then I believe it has.
The deadline
we
for
could always
404B hasn't happened yet.
Find some additional information, but I'm not anticipating that.
All right.
I think the question you need to ask is, are you still issuing subpoenas? Because as recently as 2 months ago, they're issuing subpoenas to try to find new evidence.
You're
Because
issuing
it's
subpoenas.
off the chart.
But I'm not sure that
There's a new case.
that's unlawful or against the rules, Ms. Nestor.
It is
No.
not.
Here, I need to make sure I keep it fair.
Ms.
in
Nestor,
terms
let's talk
of
about
making
your
sure
subpoenas.
that you get fair disclosure of discovery and, of course, potentially exculpatory information under Rule 16. And I hear you, Mr. Ramos, like at some point, we need to know what the universe is so we can prepare.
Yep.
So
He said you have
And-
most.
let me fast forward for a moment. Hold
There
on
aren't
a
gonna be
second.
new devices.
I apologize for cutting you off. Let me at least let you know where I'm headed, and then you can tell me why it may or may not work. I've set a pretty early witness list and exhibit list deadline of
Very
October 31.
early.
That would seem to be, starting November 1, an opportune time to actually sit down with counsel for the state in the fashion that I asked you to do before today, but which sounds like didn't actually happen. And go through the exhibit list and say, we'll stipulate to authenticity and foundation for all of these exhibits. So to the extent you're
Court's
calling
not letting that
witnesses
go.
to say, the lay Rule 90 whatever foundation for these exhibits, you don't need to. We'll stipulate that those are authentic, and we're just going to reserve our relevant or cumulative or unnecessary objections for trial. That would seem to be a way to start cutting through this. No?
Judges
Right,
like,
but if they have like 10,000 new documents they give us in the month before trial, how are we ever going to have time to do that?
you tell
Well,
the
that would
court
be-
that's late discovery, and then the court handles keeping it out or not keeping it out.
Be different. And if that actually occurs, I think you would have some arguments to make about this is unfair, Judge. You can't let him do this. But that's different than me creating
An
a
obligation
standard
that
where
doesn't
they have to
exist.
summarize the expected testimony of
Right.
the witnesses. I'm looking at Rule 16A5. It doesn't call for that.
Right.
It doesn't.
No, it doesn't.
But I can make you talk to each other.
You tried to before today.
Well, what could we go back to the idea of closing the drawbridge at some point so that we like can focus on, I mean, if their theory of the case keeps changing, I mean, at some point we have to know what their theory of the
There's a
case is,
statutory
right?
deadline.
Well, I think you're going to know more than you do now, and with some
My rules of evidence disappeared.
clarity that you haven't yet had on
annoying.
by October 31st.
Okay.
There's a deadline.
And so any objection to a court order saying that you need to meet and confer with counsel for the state to talk about exactly the kind of stipulations and streamlining that
No,
you
just
described
make them do it, because they didn't do it
during the month of November.
since the last hearing. So just make
I don't
them
think
do
you
it.
need to order it. I think we're going to end up doing it anyway. I mean, that's our whole
He
goal.
wanted
In
you to do it.
fairness, I ordered you to contact them regarding deadlines for hearings and filings, and you didn't do it.
Oh,
And
we
so I
did.
think
No, we
maybe
did.
a gentle nudge
We did contact them and they said any date was fine with them.
And
They,
then
they had no preference at all.
And
Let's
then
be a little bit more detail oriented. I need you to sit down with them and go through their.
Your Honor, we did contact them. They said any date was fine. So we proceeded to give you no dates. Let's be a little more detail oriented. He has such a great way of wording things. He is incredibly patient. Incredibly patient. We did talk to them. Did you do the next step? No? Okay.
We did contact them and they said any date was fine with them. They had no preference at all.
Let's be a little bit more detail oriented. I need you to sit down with them and go through their witness and exhibit lists and have a conversation about, all right, is that person just laying foundation for exhibits? Or how about we talk about these exhibits? We think we can stipulate to the authenticity and foundation for this list. Does that reduce the witness list at all? Just have a conversation.
We're happy to do that. I mean, we're planning on doing that anyway. That's why we wanted that early release date of the exhibits.
So during the month of November, yes?
Sure.
Mr. Ramos, is that possible?
No, it's not. That's not
Okay.
a problem. I guess one of my concerns is when we're talking about 10 terabytes of discovery, and within that
Size
discovery, there's
queens.
also duplicates,
Okay.
right? And it is not, it's organized. It's not organized in a efficient manner. And
Why don't you vertically and horizontally deduplicate it?
It's harder than you think to do that.
well,
This is what happens when you have a judge who has recently dealt with discovery. He's like, do not come in here complaining to me about what might be duplicates. Because if they didn't turn something over, Bloodworth is now annoyed and is like, this could have been an email. Because if they didn't turn something over and it was slightly different, it would be a problem. Someone has to sit down with the digital discovery and do it. I love this judge.
when we're talking about 10 terabytes of discovery, and within that discovery, there's also duplicates, right? And it is not, it's organized. It's not organized in a efficient manner. And
Why don't you vertically and horizontally deduplicate it?
It's harder than you think to do that.
well, I mean, two
You
things.
may need an e-discovery vendor to do it, but
Oh.
they would be able to horizontally and vertically deduplicate the documents. You don't have 12 copies of the same email.
We understand that, Judge, and we've started our own process. My point is this, that there is no reason why from the beginning there should be duplicates or triplicates of the documents, right? And as we get more documents that are being put in there and not organized in a certain way, it also does mess with the way that we're going about it, right? So the only thing that I guess that we're trying to make sure, we understand there's going to be rolling discovery in all cases. We're trying to find a way where we can get to a point where it's at least manageable.
just told
You mentioned the word universe. Right now, there's some black holes in that universe that we're just completely lost at times, right? And it has to do with a variety of things. I think the October deadline is going to be great. We do want to bring this to your honor's attention now. I do not see a reason why this continues, even these subpoenas 2 months after, even the trial was canceled. Regardless, though, we're bringing it up now so that we're all on the same page.
Mr.
We'll be
Bloodworth's
ready.
face.
We're just trying to be as efficient as possible when it comes to the actual trial deadline, because using your castle analogy, there might be some witnesses up there that are nothing more than jesters, and we're just sitting there. We don't want to do that.
Sometimes you don't know.
Well,
Here's the problem.
Yeah.
All right.
Here's the
let's take
problem for a
step back.
prosecutor. Sometimes witnesses might not seem relevant, and then something happens and they become incredibly relevant. They have to be on the witness list or you can't call them. Like if you don't have a player on the roster You can't have them enter the game. Damn it, I need to start using analogies from medieval times. But this is part of trial. Prosecutors over disclose because if they under disclose, it's a much bigger problem. And sometimes if prosecutors are given a duplicate police report from law enforcement and then they turn over 4 police reports when they just got 6, the defense is going to turn around and be like, but law enforcement gave you 6. Okay, well, 5 and 6 were duplicates. Okay, but law enforcement gave you 6 and you didn't give them all to us. Okay, so they all get turned over. And sometimes there are duplicates. And he said they are organized, just not in the way we want them to be. They have to be turned over and clearly identified. That's all they're obligated to do.
The rules of evidence still apply. And so if there is testimony that's simply not relevant or is it unnecessarily cumulative, it gets excluded. So you always have that tool. Second, to the extent there are black holes in the discovery, pick up the phone and be like, I don't understand where this big gap is. Third, I understand your...
Cheryl said, but why send duplicates? It's wasteful. It's digital. I mean, it might be a digital waste of space, but this is digital. And for the example I just gave, because if something gets produced to them that's duplicative and they don't turn it over, then the defense says that they're hiding it from them. So it gets all turned over.
Concern regarding...
And the court's like, you can just talk to the other side. Mr. Bloworth has been really forthcoming when the defense has asked him things in court that I've seen.
Actual trial deadline, because using
Sometimes
your castle
sassy.
analogy, there might be some witnesses up there that are nothing more than jesters, and we're just sitting there.
So
we don't want to do that.
Some of that you can just figure out, though. Like,
well,
yeah.
All right, let's take a step back. The rules of evidence still apply. And so if there is
The rules of
testimony
evidence
that's
are
simply
finite.
not relevant or is it unnecessarily cumulative, it gets excluded. So you always have that tool. Second, to the extent there are black holes in the discovery, pick up the phone and be like, I don't understand where this big gap is. Third, I understand your concern regarding getting served with
like,
another
go lawyer
terabyte of seemingly duplicate information, but a lot of that information probably has metadata. And I would understand why the state wouldn't start excluding things that it thinks are duplicates and risk not producing potentially relevant metadata.
Ding, ding, ding.
The better rule for prosecutors is to overproduce, to avoid any potential Brady issues.
That's what I just said.
I think we're just going to have to work through this by counsel meeting and conferring a number of times. I simply don't have enough information to fashion any sort of remedy sitting here today. I appreciate
There's
being
no
made aware
remedy.
of
They're
this.
just whining.
We'll take it.
Your Honor, there's no remedy. The remedy is, Your Honor, there's 10 terabytes of data. Guess what? Every trial going forward with a large digital dump of devices is going to have terabytes of data. It's just going to. You can't measure the amount of discovery just by terabytes because that might just be high resolution video. It might be full phone extractions. Every case is going to have this much digital data when people are this active on their phones.
One step at a time.
Well, I think we realize we don't have a remedy, which is why we're just making Your Honor aware of it.
Okay. I'm sincere when I say, please pick up the phone and start talking about these issues. Prior to taking the bench,
the prosecutor's going to be like,
I did a lot of complex litigation with
we can tell
a
Your
lot
Honor.
of financial information, any discovery issues.
We can tell.
And since taking the bench through things like the consolidated opioid litigation, we've had to manage the same things. These are not unique issues. They just take time and effort.
I'll bite my tongue, Judge Fair.
Okay.
Your problem is not special.
I cut you off there, Mr. Ramos. My apologies. Anything else?
No.
Mr. Ramos said, I'll bite my tongue. That's
Okay.
fair.
All right.
Your Honor, there is one matter that I think is still waiting on a ruling that I haven't heard you refer to. I just want to make sure we don't lose it. So
No, I've got it. I owe you an updated ruling regarding defendant's motion to compel disclosure of Giglio material, docket 818.
Correct. Thank you, Your Honor.
It's on the list.
Thank you.
Okay.
That's Brady material. Brady,
Counsel,
Giglio,
does it make
Giglio,
sense
Giglio.
to set a pretrial conference sometime during the month of November to check back in regarding some of these issues that Mr. Ramos has raised the court's awareness to?
We knew the court liked financial stuff when he started directly questioning the forensic accountant. I think it was during the bail hearing. It might have been during the prelim, but yes. He's also on like the Avalanche Rescue Board of Utah and some others. This judge is fascinating to me, but he's also like, look, I'm not going to yell at you about doing your job, but I am going to sass you a little bit and remind you that being an attorney in a modern age means that you have all of the benefits of technology. You also have all of the downsides of technology. So, yeah, there's a lot of data. Okay.
Sure.
Let's set a pretrial, Your Honor.
Okay. There are a sufficient number of nodding heads that's what we're going to do.
And now to pick another date. Lona said, wait, there are discovery third-party companies. Oh,
So
a lot
Ms.
of them.
Ms. Nestor. Ms. Lewis and I have a trial
She's Nestor.
that is likely to go
There are a lot
the
of
week
discovery
of
companies.
November 17th. So if we could avoid that week, I would be grateful.
This judge has been incredibly patient and fair.
No.
He's given the attorneys what they've asked for.
Yeah. So maybe the week of the
And
10th.
when he doesn't, he explains why.
We can. Do you want to be doing this the week before that trial, or would you prefer to go to, say, December 5?
But he's also not scared of them being
December
like,
5.
we have discovery. He's like, okay, meet
We can
every
do
case
that.
ever.
December 5th works for me.
Mr. Bloodworth?
He's like, yeah, whatever. If he's not in trial.
Okay. Counsel, 3:30 p.m., December 5 for a pretrial conference.
Did he say 3:30? Yes.
Happy to do it by WebEx, if that's helpful.
Great.
Ms. Lewis?
That would be fine. Yeah, let's do it by WebEx.
Okay.
Okay.
And Ms. Lewis, are you comfortable with Ms. Richins appearing by WebEx?
We are.
Okay.
Can I
December
just-
5. Oh, I'm sorry. Go ahead.
I'm sorry, I'm backtracking here. In terms of the discovery issue, and maybe I could just throw this out here. So
We had
we're
moved
talking
on.
about it. I think a lot of the problem here is that Box isn't really equipped to handle this type of discovery. It's really difficult. I mean, the Box is great in a normal case, but in this case, it's awful. I can't find hardly anything in there. You made the point, that's what I was thinking about earlier about, having someone organize this, getting a professional to organize the discovery. But on the defense side, our budget is very limited. I don't think we'd even be allowed to do that at this point, and that's going to be expensive. So I don't know if we just want to throw out there if it's something the state could look into, some way to get this organized. I have some real concerns that something is going to come up at trial that's buried in there, and none of us will have ever seen it, just because. And we're really more like at 11 terabytes at this point. We were at 10 when we took the case a year ago. We're at about 11 plus now. So anyway, I just thought that might be worth throwing out there. I don't know if that's a possibility.
They're sidestepping asking the court for funding, which I don't think is in the direct line. In Idaho, it was, and the court said, if you need more funding approved, then we have more funding approved. But remember, a lot of these things have to adhere to very specific standards of digital security. So there are only so many ways to do it. And the way it's being turned over, they're like, it's difficult to work within this technology, but it also has to be secure. And So there's, again, difficulties there, but did you guys ask for more funding? The state's not going to do it.
Your Honor, let me
I don't
make
wanna- I don't want to open a new can of worms here, though, but give me a sense for a moment. Is this 11 terabytes of PDFs? Is it a mix of file formats? Mr. Bloodworth, help me understand. Okay.
Your Honor, it's a mix. I don't know the number. I'm not disagreeing with the 11 terabyte number, but it's a mix of data formats. As the court is aware, the state shares discovery with the defense through Box. They see the exact same thing the state sees. We give them access to the Box folder that we create with all the discovery. We are both working from the exact same Box database. The defense has asked, because of their difficulty in employing Box, they have asked for the data to be provided on hard drives as well. So the state has done that as an accommodation. What they do with those hard drives, whether they get a vendor separate from Box to organize the material, this
And this is where you lose me. You don't like dealing with Box, the technology that holds the drive. You asked for hard drives. We gave you hard drives, which, by the way, would be at the state's expense because the state would have to buy the hard drive to download the discovery and then give it to them. And they're still sitting here saying, but Your Honor, the defense, but Your Honor, the prosecution isn't accommodating us. No wonder Mr. Bloodworth's face is like, you got to be fucking joking me. This is not an issue to complain about. When issues that aren't issues are made issues, you lose me. The state has accommodated quite a lot, where in Massachusetts, I lose my mind at the Commonwealth just being like, Matt, it's fine. Here, the defense is like, but Your Honor, it's hard to organize the cloud drive. And the prosecution's like, right. And so we gave you a physical drive. And they're like, it's 11 terabytes. It's a lot. And the state is like, we have the exact same drive that we're all working off of. What's organized for you is the exact same way it's organized for me. And Box has some organizational features within it. Also, if you have hard drives, you can put it somewhere secure and reorganize it for yourself. There are 3 attorneys. There are 3 of you on a single victim homicide case. 3 attorneys.
State has we have no say in that regard. They can do it. The state doesn't control their budget. I don't even know if they've asked.
Well, I think the state does control our budget, but maybe not.
Well,
you,
I think he
but
the Summit County.
Ma'am, now is not the time. Yes, the state of Utah controls your budget. No, the state prosecutor's office doesn't control your budget. This case has been delayed and delayed and delayed. And now we are starting to see, but Your Honor, it's a lot of discovery. If y'all make a motion to continue in January, I'm going to lose my mind. Griffin is going to come in here and be like, that's a skill issue. It's not.
Separate from Box to organize the material. The state has we have no say in that regard. They can do it. The state doesn't control their budget. I don't even know if they've asked.
well, I think the state does control our budget, but maybe not.
Well,
you,
I think he
but
the Summit County Attorney's Office, and they don't.
And
Brad
I,
doesn't control our budget,
I don't
as
know.
far as I know.
Nobody's on this page with you right now, ma'am.
I don't, as far as I know, they could be using the identical box we use. They could be using the data in a different, with a different vendor. They could have asked for money. They could have chosen not to ask for money. I don't know.
This
but
is
we
not my
turn over
problem.
everything we have in the same format
Right.
that we view it.
This is not a him problem. We've turned over everything the way that we get it. And then we gave you hard drives as well. 10 terabytes of hard drives. If y'all need more money, ask somebody for more money. We need to send Mr. Bloodworth a tiny violin. Don't do it. Don't send Mr. Bloodworth a tiny violin. It's for the lols. Lawyers have lots of organizational work to do. This is not shocking for anyone.
Let's pause for a moment. We have time to have reasonable conversations about this. Now, part of this will be,
I'm waiting for Mr. Bloodworth to pull up the tiny hands.
if not simplified, at least focused when the state makes decisions about its exhibit list. And that exhibit list is going to have to be sufficiently detailed to allow defense counsel to understand what exactly Exhibit 42 is and where to find it.
We've prepared a near final version of the exhibit list. It identifies documents by Bates numbers, and then we have created a separate folder in Box.
Everything is Bates stamped, and they're identifying the exhibits by Bates numbers. Bates means continuous numbering. 1 through 1,000, whatever. It's all Bates stamped. He's like, you all have it. No wonder he's sitting here going, what is the problem? You've got everything we've got, and you've got it numbered in order.
We've prepared a near final version of the exhibit list. It identifies documents by Bates numbers, and then we have created a separate folder in Box, organized by Bates number, of every single document we intend to use as an exhibit.
And has that been shared with defense counsel to date?
Not yet.
That will be once we
finalize
the exhibit list and turn it over on October 31st.
Hold on.
Sorry, Brad.
Everybody pause. Mr. Bloodworth, understanding that whatever the working version is not the final version. Is there any reason you can't share what you've identified?
Yes, because they'll whine about it.
Separated to date to at least allow them to start working?
Your Honor, they've had this material since the moment they came on the case.
I asked a yes or no question about a folder that they don't currently have access to.
Because they will fight him that something's not in it. You know that they will. The court will shut them down, but they'll be like, but then they keep adding things to the folder, Your Honor. You can hear the arguments now. Can you just turn it over? No. Because they'll say, but Your Honor, he kept adding things to it until October 31st. Don't make them do it before the deadline. Mr. Blower's going to push back on this, I would imagine. The judge is like, well, if it's almost done, can you give it to them now? No, because he doesn't have to. It's not the deadline. They're not turning over their witness list until like 2 days before jury selection starts. They have enough time. They've been on this case for what, 2.5 years?
They have been able to have worked. Nothing we're doing.
I asked a yes or no question about the folder that they don't yet have access to.
No. It's work product at this point.
Any reason that it would be unfair
Yes.
To say, well, listen, we know, or sitting here today, we currently think we're going to use these. This case was set for trial months ago. Why can't we just give them access to what you've identified so far?
Because it's going to cause more problems.
You have between now and October 31 to change your mind, to add stuff, take stuff out.
Because it's going to cause problems.
Your Honor, we could probably do that. It would take some work assembling it, but we could do that before October 31st for sure.
Perhaps I misunderstood. And so I'm not trying to create a folder that doesn't presently exist. I thought I heard you say there presently is a working version of a box folder that has separately identified exhibits that the state presently intends to include on its exhibit list.
That is correct. There's a working version. We are trying to populate that box folder
It's just not done yet.
Okay.
as we're building out our exhibit list.
So
Why can't you
By
just give
August
them what you
15,
have?
send them a draft or access to a draft of the folder. Understanding it's not going to be complete.
They're going to complain
It's
about
not
it.
going to be final, and it does not prejudice the state's rights to add or withdraw exhibits from it in any way.
Understood.
Mr.
And
Ramos, then you and the state will be in the exact same position.
You know what that draft folder is going to look like? Draft folder with police reports and the coroner report in it, which they already know that the state's going to use. That's what it's going to look like. You can tell what the state's going to use in this case. The coroner report, the digital downloads, the walk the dog letter, text messages, phone extractions.
And I will commit that if we know immediately that there's documents in there, we are not going to challenge authenticity. I promise we will let him know very quickly so he doesn't even have to waste time subpoenaing those witnesses.
Okay.
Well, at least there's a benefit to
Because
doing
that's
it.
very helpful to us to wade through the noise.
Now, to be clear, Ms. Nestor, Ms. Lewis, Mr. Ramos, you heard me say it's not going to prejudice the state's right to add, withdraw,
Of course.
change
Yes,
its
of course.
mind.
He knows
prior
where this
to
is going to
October
go.
31.
Right.
No, and I think, and Judge, I think the
Don't come up
issue
here and
has been,
bitch.
it's not that we haven't had him. At no point, and I'm not sure why Mr. Bloodworth would insinuate that we don't have access or that we think he's hiding anything.
He didn't insinuate that. You complained that the discovery wasn't organized the right way. And Mr. Bloodworth says, you guys have it exactly the way we have it. And in fact, we gave it to you 2 different ways. But the court already knows where they're going to go. The court is like, you heard me say, I am not going to listen to you complain that they changed something in that drive. But Mr. Ramos, you complained about the discovery. Mr. Bloodworth set the table and said, we've given it to you in a bunch of different ways. And then you're like, well, Your Honor, I don't know why he thinks we're insinuating that. You said it. That's why. Everything was going towards the end of the hearing. And then it was like, but wait, Your Honor, there's black holes of discovery. I don't know why they're insinuating we haven't given them something.
To add, withdraw, change
Yes,
its
of course.
mind prior to October 31, right?
No, and I think, and Judge, I think the issue has been, it's not that we haven't had him. At no point, and I'm not sure why Mr. Bloodworth would insinuate that we don't have access or that we think he's hiding anything. That is not the case. The point of it is we have a lot of information, which we have been going through, so disagree with that. We're going to trial on a case that I guarantee is not going to take up 11 terabytes of information.
Right.
It will not. Okay.
I understand.
And so, but what we wanted to do was to try to get that universe very, very, very small if we could. We understand they have to provide everything to us. I think this is a fantastic solution to it that will make things very clean. So we really appreciate that August 15th deadline, Judge.
Yeah, I'm not inferring any bad faith or lack of diligence on anybody. I think we're just recognizing that the 16A1 disclosure obligation is like this big, and the 16A5 pretrial exhibit disclosure obligation is like this big. And so this will help get both sides of the V from the big bubble closer to the smaller one that's going to be used at trial.
Yes, sir. Thank you.
Okay.
Everyone can see what they're going to use coming from a mile away. I understand that they want to make sure there are no surprises. But Again, you already see, chat, you've already clocked it where the court said, can you please try to share a draft of this by August 15th? And the defense is already sitting there going, oh, for the August 15th deadline. And Mr. Bloodworth is going to start going, if we give an inch to help, they are literally going to take a mile. And that's where prosecutors start going, no, fuck that. I'm not doing any of it. Because it's that we're trying to help and we've just made more work for ourselves because now it's going to cause problems. Because it's gone from a courtesy to a thank you for that deadline. Did you see how quick it happened? Right.
Let me just go around the table one more time. Mr. Bloodworth, anything else?
Yeah, we were done.
Ms. Shervinack?
No, Your Honor.
And then
Mr.
the defense
Burns.
went, one more thing.
Ms. Lewis?
No, Your Honor.
Ms. Nestor?
Yes, sir.
Mr. Ramos?
It's almost 5.
All right, very good.
Really, it's 5
December
o'clock
5.
somewhere.
What time did I say? 3:30? 3:30 p.m. by WebEx. I wish you and your clients and your families the very best. If anything emergency comes up, please let me know. We will contact Ms. Young, Summit County, to determine the terms of the conflict contract and figure out what's possible in terms of appointment of counsel on the newly filed case. We'll schedule an initial appearance and send out notice. I wish you all the very best. Please take care.
Thank you.
The end of that was exhausting. Just exhausting. All right. We are done with, I got a doodly bopper on the top of my head that's just doing its own thing. We are at the end of court for a scheduling conference in the Kouri Richins case that was trying to set deadlines, and by the end of court ended up sounding very much like we were back in court in Idaho. But Your Honor, there's 10 terabytes of data. By the end of the hearing, it was, but Your Honor, there's 11 terabytes of data. And asking the prosecution team to narrow down the discovery that will be used at trial prior to their deadlines. And the prosecution said, we will get you what we have. We will get you what we're working on. This case has been continued. But Mr. Bloodworth also at one point said, you all have had the same discovery we have had since you came onto the case, when the prior defense attorney was no longer on the case. So the defense team has had this discovery as long as the prosecution has. The prosecution said, when we get it, we turn it over. And we also took it from not just the cloud drive through Box, but we also provided it on hard drives. You have the discovery. And the defense said, but Your Honor, they're still sending out subpoenas. There's a second case against Kouri Richins with 26 counts. And if the prosecution discovers new things, they can follow up on it. Because if the prosecution discovered something new and didn't follow up on it, there would also be an argument. But Your Honor, they never followed up on this lead, even though it came up before trial or during trial. They needed to follow up on it, and they didn't. So the defense is arguing a little bit of a sword and a shield here. And the court did ask the prosecution to work with the defense a bit. And if they had a draft of a drive that had mostly the trial exhibits in it, they would turn it over. But everything is bait stamped. So it is organized sequentially. And then the defense was like, but some things are duplicates. And the court said, so take care of it. And the court said exactly what I said with, hey, if the prosecution started selecting what they turned over and turned over some things and didn't turn over other things, then that would become a problem. So over disclosure, not under disclosure. And the prosecution said they have everything that we have. They have everything within our control. If there are things still outstanding that we do not have yet, we will turn them over when we get them. So the prosecution is like, fine, Your Honor. We'll do what the court asks. But then there are 3 different defense attorneys talking in the hearing about different aspects of discovery. And at some point it feels like they just go, but yes, and push for just a little bit more, even when the hearing was just about done. However, I will be livid if we see some type of motion to continue. This was set to go to trial in May. It got continued because of the rulings on the motion to change venue. And then it got bumped from May 2025 to February 2026. They should have gotten ready for trial in May. They were close to trial. And the defense is like, but they're just charging her with so many things. Well, you can decide if that's reasonable or not in my videos covering those indictments. So the Kouri Richins case is speeding to trial and to some trial deadlines. We have gone over the civil cases. Those are all now paused. Essentially, they are stayed pending the criminal case. So once the criminal case is done, we will continue to take a look at those. There are some motions in the criminal case we have not gone over yet. We will probably do so in September, October, ahead of those hearings in December, and just take a stream or two and go over all the rest of those motions, because we do have the Donna Adelson case coming up for trial at the end of August. And so we will be shifting focus a little bit to what's been going on in court there. But this case is proceeding, the Richins case is proceeding normally. It is, people have been working together. The attorneys have largely accommodated one another. The court has been patient and decisive. And I appreciate seeing the more normal aspects of trial where we're not sitting here going, wait, what? Every single hearing. So it's nice to see a case proceeding pretty normally. And yes, a lot of lawyer work is, could this have been an email? And if you're confused about the discovery, why didn't you just send me an email and ask? And Mr. Bloodworth does not seem to be the type of attorney that is going to just ignore you. It seems like he'll tell you what you need to know. And then if he can't tell you yet, he'll tell you he can't tell you. But if they haven't even reached out, Bloodworth said exactly what I was saying. Have they even asked for more funding to get help with the discovery? I don't think they have, because they are conflict counsel. So the defense attorneys are not hired by the public defender's office. I'm just moving my notebook. They're not hired by the public defender's office. They are panel attorneys that are appointed to the case, and they have other trials and what have you. But also everything is being used through a box drive. It seems like it's going to be pretty easy for them to sort. BT said, when is Kouri's financial trial? They haven't even had an initial appearance yet. It is going to be pretty far out after the murder trial, and we haven't even started it. So they haven't even appointed lawyers on it yet. It's going to be out for a bit. I want to know when we're going to have a hearing on the motion to quash the subpoena between the defense attorney and the victim's family's victim's advocate attorney. That I want to see. That I want to see immediately. So for all of you that are newer to the Kouri Richins case, this is going to be one of the trials we're following. The caveat on that, this judge has forbidden streaming in every prior hearing. Things have been allowed to be recorded and uploaded later. I don't know what the court is going to do when trial starts. So we are going to have to figure it out. I don't want to go to Summit County in February. It will be cold. But we will try to figure out what we are going to do. So hopefully the court will allow a little bit maybe of a stream on delay. I don't know. We have time to figure it out, but the court does not allow it to be streamed in real time. So we're just going to have to wait and see what happens. Maybe the court will change their mind. Maybe not. So we're going to get to some questions, and I've got to go because I have obligations. I have banned parent obligations. Oh, I have my rules of evidence out. We can talk about 404. I have banned parent obligations. Marianne Rogers said, Emily, you can ski in February. I wish I could still ski, but between the knee that it's cranky and the rest of it, I would probably just hurt myself. I could go toboggan. I could sit in the lodge with a steamy drink and a book. That is more my vibe. I don't mind walking through the snow, but I will find a way to hurt myself. I love to ski, but it's not going to it's not going to be my ministry anymore. The bad knee is just not getting better. So we'll try to keep ourselves upright. All right, snow tubing. Yes. Let's get to questions, shall we? Real quick. Ems said in the chat, the drink's steamy, but not the books. It depends if I'm reading it on Audible or holding a copy of it with a cover or reading it on an e-reader. It just depends on how I'm reading it. It does. To all of our new members, welcome. We have had incredible generosity in the chat from B2 and others gifting a ton of memberships today. So thank you so much. Jojo said, EDB, I'm curious, how do they sort through evidence? However they want to. Every attorney, I'm sure, has a different way of doing it. I used to just summarize things as they were coming in. So it would have the Bates numbers and then my own like quick summary if I needed to. So it depends on each attorney. Larissa asked, did they make a ruling on the walk the dog letter? No. The ruling on the walk the dog letter is being held until later. So it's going to come up in those hearings that the court set for December. So we will see it then. Emily, please explain impeachment. I said I was going to hold on to this till a little bit later. Impeachment is, well, I'm going to try to simplify and reframe, but it is, let's use a real life example with the Karen Reed case. In the Karen Reed case, when the expert got up and was talking all about his resume, and then the defense got up and was like, but on LinkedIn, it says this. The LinkedIn information would be impeachment. It doesn't come up if the witness doesn't say something contradictory about it or present something contradictory about it. It doesn't even come up if the witness is like, oh, I don't know, my company does my LinkedIn page. I have no idea what it is. Then it doesn't come up. But if it is contradictory, then it is outside information that's never going to come up unless the witness says something different. So the LinkedIn page is what would have been impeachment, and that doesn't have to get, in most jurisdictions, turned over because you're not going to use it to impeach the witness or show that they were being untruthful about something unless the witness is untruthful. If the witness is not untruthful about something, then it never even comes up because they've just owned it. So that would be impeachment. It does not have to be turned over. Lan said, EDB, it happened in the YSL trial. It's fair that in the YSL trial, the judge required summaries, but the prosecution was so disorganized in that case, and it was such a sprawling cluster that I don't blame the judge, because there were days when the prosecution didn't seem to know what they were doing in the YSL case. And the court's like, you got to explain it to everybody. I get it. Nick said, member for 48 months, 4 years, almost my longest relationship. Well, Nick, welcome. We're happy to have you here. The Lawnards are here for life. CCC said, appreciate this place. Thank you. I appreciate it too. ADHD teacher brain said, kindergarten is my favorite to teach. The enthusiasm is really fun, right? We love that. Judge Butthead in the chat said, our dentist name is Beavers and their whole family are dentists. They all practice together. They are the Beaver dentist family. That's hilarious. At least they didn't go into gynecology. I mean, though it would have been funny. It would have been hilarious. we have had a couple streams where we've talked about doctors with appropriate names. It's fun. It's fun. Let's see. Wedge said, Jesus, how long has this thing been on for? It seems like it's been going forever, or maybe that's just me. Wedge, we picked up the Richins case shortly after her arrest in May of 2022. It was set for trial after she changed attorneys in May of 2025. And now that has been bumped to 2026. So, yep. My honey said, I love the maple breakfast tea. So delicious. I was talking about, should I have just gotten some tea earlier, and would have gotten the maple breakfast tea collab with David's Teas and Christine at Hollow Taco from Simply Neological. EDB, will Eric's family get the monies from the insurance Kouri took out? That is part of the civil case. That's not going to be determined by the criminal case. So that is all part of the civil. Well, the criminal case will aid the civil cases along. So we will still see. Brandy is still crossing my fingers for Docket 214 merch. We will see. We will see. It will probably be Easter egg type merch for sure. Karen said, Emily, I'm going to go watch the Cavaliers practice tonight. They're in my hometown at my high school I attended. Have the most fun. Their show has cleaned beautifully. Have fun. I really enjoyed getting to go watch them practice. I only got to do it once this summer. I loved it. I can't wait to get to do it again. I can't wait to see Travis and Indy. I can't believe it. I can't believe he's been gone for this long. Also, it has gone so quickly. I can't believe we're almost at the end of the DCI season. I mentioned it yesterday. I will mention it again today. For those of you that have asked, yes, Thursday's event is in movie theaters. However, if that is not your speed, Emily D. Band, the Law Nerds came up with that name, EmilyDBand.com has the 1-year discount or the discount on the annual plan on FloMarching. It is an affiliate with Flo. I asked them I was like, can we do a discount before we even worry about an affiliate? And they were like, yes, we can. So we have an affiliate code and a discount for you if you sign up for a year. If you don't sign up for a year, you can sign up for 1 month and cover the rebroadcasts that you want to see and finals. Finals run all day on like Thursday, half the day on Friday, and then Saturday as well. So if you are just like, I want to sign up for a month and watch all the finals, you can. If you want a 1-year discount, you can. We are the only discount with FloMarching that exists because we are persistent. And so if you want the 1 year and you want to be able to watch other Flow properties like WGI and like some of the college stuff, you absolutely can, because there is lots of crossover. You can watch BOA there as well. And if you love Winter Guard, you can. So 15, the link is there. Emily D. Band will put the link in the chat if you want to go. You have to go through the page to get the 15% discount. And if you want to go watch finals, I will be there. I'll do some behind the scenes on social to the best of my ability, but my main focus is going to be band momming. But I want to record and bring you along for that experience when I can. So that. Ippy Fluffy said, wait, we haven't broken it yet? Not to my knowledge. Not to my knowledge. Redondo Beach said, can we change to a year? I don't. It depends on how you signed up. So I don't know. But it depends on how you signed up. But they have customer service through their site. So I don't know. It might require you canceling and then redoing it, but I'm not sure. So they should have customer service through their site. You can ask them to change it if you want to. Let's see. Good to see you, J. Michael. J. Michael said, almost 4 years of my internet bestie. What a great year. 47 months on my 47th birthday, right? Because we are the same age. Happy birthday, J. Michael. And we had lots of birthday buddies in the chat. It's good to see everybody in the chat today. Matt Bond, good to see you. Super spiffy, legal mumbo jumbo, talkie law nerds. Yes. I might actually do members another tech test because I have something I want to unbox. So I might go grab it and then do a members tech test real quick. So let me go look at what time I need to be out of the house to go do band mom stuff because I'm excited. So let's see. Just Rhonda said, I would love to start a poll. How many law nerds live in Utah? I'll start. We can ask another time. Right now, we have had a disproportionate amount of law nerds in Massachusetts, but it shifts case by case. Stacy, not her mom, said my guy knows Dr. Pink. I love it so much. I love it so much. Look, there are just some things that are so fun. Tony said, have the best time in Indy. Go Crown. Tony, it's so good to see you in the chat, and I'm sure they will be great. I gotta say, there are some things I would like to see for the Cavaliers that I'm excited about. I think they've had a great season. They have a great show. Also, I'm not going to start talking about slotting. I will just get derailed. But I'm really excited to see how Boston does. They have been climbing with their shows. It feels like their year, like the vibes are right. So I love so many of the cores. I would really love to see Boston get their first win this year. Maybe I'm just rooting for Boston. I'm like, look, man, we've spent a lot of time in Boston. Boston's had some rough years. Give Boston the W. Boston deserves a W. Boom is a great show. It feels like time to me. Boston, it's their time. Also, it keeps the top 5 really competitive. I love seeing cores moving around and pushing to higher and higher scores and pushing the sport forward. So I'm excited. Law nerds, I have band mom duties today. I have driving duties tomorrow. I will be back on Tuesday. I will be on social and in the Law Nerd Lounge behind the scenes. I have some stuff to share with you guys there. And I will be back Tuesday. I can't tell you exactly what we're covering. I have something in my notes. I just don't remember what it is. Law Nerd members, I will pop into the member spaces if I have time to do a quick, it will be quick, but if I have time to do a quick follow-up tech test, because I would love to. So we will see how that goes. So with that, you guys, no stream tomorrow because travel. Finals weekend, I will see you soon. We have a discount for you at emilydband.com. That is an affiliate link. And that is just amazing that we were able to do a discount. I look so forward to what we're able to do next season. And that's about it for the weekend. And then I get to bring my kiddo home. I am so ready to have like everybody back in one house. I was not emotionally prepared. So law nerds, I will see you soon. Have a great weekend. Take care of yourself. Take care of each other. Thank you for being here. Thank you for being a law nerd. Thank you for riding with me, even on the cases that you might not know that you love yet. We have much to talk about in the coming weeks because Donna Adelson is moving pretty quickly towards trial. So fingers crossed that trial starts when it's supposed to. All right, law nerds, have a great weekend. I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.